Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. Not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade, sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and Machegas. Ridiculous that insanus. Oy vey, Marcus. Proceed, that's for schmucks. Be cool, be kind, be classy. My cupcakes are sweet and sassy. Not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Good morning. Good morning, my friends. It is Monday, July 21st of 2025. Thanks so much for coming to hang around with me today for a little while. Seeing what we're doing here. How's everybody? What's up? Thanks for coming back. For those of you who were with me last night for the Turtle Boy interview with Aiden Carney, we spent about 3 hours together. It was a lot of fun. We had a lot of laughs. There were some tears. A lot of people have been commenting on the show that they were crying. Jimmy said he was crying big gay tears when he was in his car. I love Jimmy and I love Nurse Kim. And I think everyone had an amazing interview. And we're all different people, so we all interview in different ways. We all ask different questions. I think each of us, Kim and Jimmy and I, all brought out different things in our subject, Aiden Carney. And I tried so hard not to ask the same old questions and not to, because I know the case. It's a lot different when you're talking to somebody who knows the case. You don't have to get into how did you get interested in the Karen Reed trial and, things like that. So hope you guys liked it. There were a lot of things that you might have learned about Aiden Carney that you didn't know. And that was the idea, to have a conversation and to joke around. And I thought it was great. I thought we had a great time. It cracked me up that so many people thought that, for some reason we had some beef and we like each other. So listen, Aiden Carney, the guy is a lot different than some people think from watching his show. He's a lot different in real life. And so it was and I loved Andrea's. I loved Andrea's as well. And, Runkles, I watched some of it. I don't know if I watched a lot. Listen, I'm on YouTube so much that it's really, really hard for me to watch other creators' shows. But I did watch Nurse Kim and Jimmy because I love them both. And I think I was just sitting outside doing yard work or something when I was listening to it. So that was fun. So is anybody boots on the ground today in Norfolk Superior Court? Do I have anybody out there? Is there anybody out there? Hello? Is there anybody out there? Just nod if you can hear me. Is there anyone home? Here's what's happening today. So today, Rosemary Scapiccio, who many of you may know from Trial 4. I did not watch Trial 4. I'm not as familiar with her from that show as I am from just seeing her do interviews and news clips in other cases. She's a pistol, man. It's fire, this woman. She's a defense attorney in Massachusetts. She's representing a man named Myles King. And what happened last week was defense attorneys in all of the cases in which Proctor is an investigator that are currently pending were notified that Proctor's text messages were going to be destroyed on July 31st, I think. July 31st? Or they were notified the day before Let me get my details right, because I've been focusing on prepping for Aiden's interview, and so therefore they were notified the day before these text messages were supposed to be destroyed. And so they filed motions in court to prevent the destruction of this iCloud account of Proctor's, because since he's on the Brady list, and but a lot of it hadn't been turned over to the other defendants. I see what you're saying. They turned it over to some. They didn't turn it over to others. So let's look at an article here, because it's going to be easier than me trying to explain it to you. So here's what had happened. What had happened was, and this is dated July 18th. Today is what? Today's the 21st. So this is from Friday. And this is WCVB Channel 5. Here's, let's listen to the story and then we'll read the article.
Good afternoon, Shayna. Will you?
Oh.
You'll remember that Michael Proctor admitted to sending those vulgar and insulting text messages about Karen Reed while investigating her for the death of John O'Keefe. And the state police later fired Proctor, in part for creating what the state police called an image of bias against Karen Reed. Well, now more criminal defendants are demanding to see if Michael Proctor said anything similar about them. Federal investigators uncovered Proctor's text messages about Karen Reed and then turned them over to the district attorney's office here in Norfolk County. But that sharing from the feds also came with a condition that all of Proctor's texts and emails be destroyed or returned to the feds 30 days after the Reed trial ended. Now, normally that would be today.
Okay. Let's just spy who's in the courtroom. Is that Krowski Jr. right here to the closest to the front of the screen? I think that's Rosemary Scapiccio on the left with the blonde hair. And this was not televised or widely publicized, because then I think this was on Thursday, and then they were told to come back on Friday. And so Friday I was stalking the court docket to find out what time it was going to be. It didn't even wind up on the calendar, but I think it happened Friday at 3. So let's take a look.
Today, defense attorneys are asking a state judge to block any of those communications today. That all of Proctor's texts and emails be destroyed or returned to the feds 30 days after the Reed trial ended. Now, normally that would be today. Defense attorneys are asking a state judge to block any of those communications from being deleted.
Proctor called a white woman the C word. What do you think he's calling black and brown people?
Yeah.
That's what we're worried about.
That's Rosemary.
What do you think he's saying? Why are they so intent on destroying this information? All we wanted to do was preserve it so that we could look at it, so the district attorney's office could look at it.
In court today, the district attorney's office promised not to destroy any of Proctor's communications for at least one more week while they try to get more guidance from the feds. Now, during Reed's first trial, Proctor testified that he wrote the text messages because he was upset about the death of a fellow police officer, John O'Keefe. Defense attorneys said outside court that Proctor has been involved in at least 24 other criminal investigations that are now in various stages of prosecution. Live in Dedham, David Bieniek, WCVB.
24 other cases. The fallout from Proctor is going to be huge, and I've been saying this since the beginning.
This is bureaucracy at a
Okay, that is something that has nothing to do with what we're talking about. But here's the article from Friday. Attorneys for several criminal defendants are asking courts to stop the destruction of electronic records from a former Massachusetts State Police Trooper.
Hundreds
Michael
of delays
Proctor.
and cancellations are filling the notification boards at
Michael Proctor, who lost his job in the wake of testimony during Karen Reed's first trial. Proctor was terminated by the agency in March prior to the start of Reed's second trial after months of suspension. During the first trial, Proctor was questioned about messages he shared with a group of friends. After reading one of the messages, in which he called Reed a whack job and an expletive, he apologized to the jury for his unprofessional comments. In quotes, unprofessional. In another text message, Proctor told his sister that he hoped Reed would kill herself. Proctor described his messages as, quote, very regrettable. Data from Proctor's iCloud was obtained during an FBI investigation into the handling of the O'Keefe murder case. A federal court order mandated the destruction of the records 30 days after the conclusion of Reed's case, but attorneys representing defendants in other cases investigated by Proctor are arguing they only learned of the imminent deadline on Thursday. So remember, Karen Reed was acquitted on June 18th. That day will be forever ingrained in our memories. And so that meant that by July 18th, the records were to be destroyed pursuant to the federal court order. Quote, if they have copies of emails on Trooper Proctor's iCloud that they're aware of, that they have custody of, once we ask for them, they have an obligation. They don't have to turn over the actual email, but they absolutely have to turn over exculpatory information within the email to us, said defense attorney Rosemary Scapiccio, who represents 2 homicide defendants investigated by Proctor. In the Norfolk Superior Court on Thursday, discussions revealed that the order itself is confidential. The judge requested a copy of the order and urged the defense attorneys to seek relief from the federal judge who issued it. In court on Friday, the district attorney's office promised not to destroy the materials for at least 1 more week while they seek more guidance from federal officials. So that was Thursday and Friday. And then
well, we heard his name a lot during Karen Reed's 2 trials. Michael Proctor, he's the former Massachusetts state trooper who was fired in part for his behavior during the police investigation into Karen Reed. And we've since learned that Proctor connected to a handful of other murder cases, and there were hearings today in 2 different courts. NBC 10's Oscar Margain joins us live in Dedham. Oscar, many of these cases with Proctor's fingerprints on it have not been able to proceed. So explain that for us.
That's right, Matt. And we're talking about a few dozen cases here where that have been impacted by former Trooper Proctor. A handful of them are being heard here at Norfolk Superior Court. 4 defendants, all part of separate cases, were present in a Dedham court Friday where their lawyers scrambled to prevent the destruction of evidence that was set to expire, linked to former state police investigator Michael Proctor. The attorneys argued Proctor had a crucial role in the handling of each of their cases, and that evidence they rely on has been kept from them by the state.
That the Commonwealth has an obligation to review evidence in its custody for exculpatory evidence for our clients, and they have not done that since February of 2024.
Rosemary Scapiccio is representing suspected gunman Myles King, a 25-year-old accused of murdering Marcus Simmons in July of 2021 in Milton. Scapiccio says that she and other attorneys have been waiting for the state to release evidence, including 3,000 to 5,000 pieces of communication from Proctor's cloud storage that they've been waiting to review.
So we're literally putting out a fire here. And had we not appeared yesterday in court, had we not asked the court to stop them from destroying this information, they would have just sent it back to the feds and it would have got destroyed, and we never would have had the opportunity to look through it.
Proctor was the lead investigator in the Karen Reed case and was found to have mishandled evidence and acted inappropriately. He was later fired by the state police board in March.
We are entitled to look at all of this information and make it
yeah, that's Krowski. You might know him from Court TV. Boy, did he hate Karen Reed. His father, Joe Krowski Sr., was in the courtroom every single day during Karen Reed's trial. Apparently, he's like besties with Hank Brennan, or he was Hank Brennan's biggest cheerleader or something.
determination for ourselves whether or not it's exculpatory.
Joseph Krowski Jr. says the information is crucial for the 24 or so cases Proctor had a hand in.
Any malfeasance or misconduct in one case attributable to an officer is relevant, germane, and discoverable in other cases.
Yeah, how about him doing a 180? Right, I'll allow it. Krowski doing a 180 on Court TV. He was spewing that Karen Reed was guilty. You know, I don't know what he ever said about Proctor on Court TV. If anybody can point me to anything he ever said about Proctor or his text messages not being a big deal. Now he's in court arguing that, you know, we're absolutely entitled to it. He's a scumbag. You know, the audacity, Tiff.
Now, Michael Proctor and two other assistant district attorneys have been summoned to testify on Monday here at Norfolk Superior Court, specifically on the King case. Now, as for preserving Proctor's evidence here, there's a hearing scheduled for next Friday on that. The state here has not disclosed or explained why this evidence has not been shared. Reporting live in Dedham, Oscar Margain, NBC 10 Boston.
Common sense investigator saying that he absolutely said that Proctor is not a problem. Stop. And then somebody else said here that he definitely said the text messages weren't a big problem. Vicki Clark said. But now, you know, now it's beneficial to him. Welcome to everyone who came over from Auntie Deb. Auntie Deb was just about to read. I was watching Auntie Deb, and he was just about to read another chapter from Yellow Cottage Cheese's book for summer reading. And I was looking forward to that. Hang on. Here's the article that says, this is from Friday as well. The fallout from former Massachusetts State Trooper Michael Proctor's alleged misconduct in the Karen Reed investigation is rippling across multiple criminal cases, including several murder trials. On Friday, 4 defendants appeared in Norfolk Superior Court in Dedham, where their attorneys scrambled to prevent the scheduled destruction of key evidence linked to Proctor. The cases, all separate, share Proctor as a common thread, playing a significant role in the investigations. The Commonwealth has an obligation to review evidence in its custody for exculpatory evidence for our clients, and they have not done that since February of 2024, said Rosemary Scapiccio, the defense attorney representing 25-year-old Myles King. King is accused of fatally shooting Marquise Simmons in Milton back in July of 2021. Okay, 4 years ago, this guy has not had a trial. I heard Betterow say the other day that Massachusetts doesn't have a speedy trial statute. 4 years, this guy's still waiting for a trial? That's wild to me. Former Massachusetts State Police Trooper Michael Proctor was the lead investigator into John O'Keefe's death. He was fired after unprofessional text messages he sent came to light in Karen Reed's first trial. Scapiccio said she and other attorneys have been waiting months for the state to release critical evidence, including between 3,000 and 5,000 pieces of communication stored in Proctor's iCloud account. We're literally putting out a fire here, Scapiccio said. Had we not appeared yesterday in court, had we not asked the court to stop them from destroying this information, they would have just sent it back to the feds. And it would have, well, that says bot destroyed, but I think it means been destroyed. And we never would have had the opportunity to look through it. Proctor, who was the lead investigator in the death of Boston police officer John O'Keefe, was fired in March after being found to have mishandled evidence and acted inappropriately during the high-profile investigation. At Reed's first trial last year, he testified about inappropriate texts he sent about her and the case to family, friends, and state police colleagues. Now, attorneys representing defendants in a few dozen other cases want access to all materials tied to Proctor to determine whether any misconduct impacted their clients. For example, I will point out, was he looking for nudes of Anna Walsh? What do you think? Is it something he did in every case or just something he did in the Karen Reed case? Where was I? Now, attorneys representing defendants in a few dozen other cases want access to all materials tied to Proctor to determine whether any misconduct impacted their clients. We are entitled to look at all of this information and make a determination for ourselves whether or not it's exculpatory, said Joseph Krowski Jr., who is representing Giovanni de los Santos, charged in the deadly shooting of Ivanildo Cabral in Randolph 3 years ago. Quote, any malfeasance or misconduct in one case attributable to an officer is relevant, germane, and discoverable in other cases, Krowski added. We have a right to go over it and make sure the pitch to the court that it's admissible and make the pitch to the court that it's admissible and relevant. Remember, Joe Krowski Jr. also represented Colin Albert at one time. Proctor, along with 2 assistant district attorneys, has been ordered to testify on Monday in the King case. 2? Well, I knew about Lally. Who's the other one? An unnamed, is it Laura McLaughlin? Meanwhile, defense attorneys across various cases where Proctor was involved are now requesting U.S. District Court Judge Denise Casper, write that down, to preserve and release the former trooper's communications. So they said they would preserve them for a week. So there's a motion to dismiss today in the Myles King case that is on the calendar for 9 o'clock in front of Judge Krupp. So I called the court and I said, is there going to be a public Zoom link for the Myles King hearing today? It's an evidentiary hearing on the motion to dismiss. My guess is that Rosemary Scapiccio subpoenaed Proctor, Lally, and perhaps, I don't know who the other ADA is on the Myles King case, Laura McLaughlin, to come in and testify about certain things. And she said, no, there's no public Zoom link. And I said, okay, well, are there cameras in the courtroom? She said, yes, I just saw the cameras go in. I said, do you know who it was? She said, well, now you're really asking for a lot. Like, not really. Like, if you saw them walk by with a microphone that said WCVB on it, or Law and Crime or Court TV, I'm not really asking a lot. Public has a right to know. They don't want you to know. So they're not going to put out a public Zoom link like they usually do for every all the hearings that are in criminal 1, which is where it is today, I believe. I think it's in criminal 1 with Judge Krupp. And this is exactly what should have happened during the Karen Read case. When the defense team filed a motion to dismiss based on extraordinary governmental misconduct, based on failure to turn over Sally Port video, jury tampering, the fact that Fanning might have been involved in the jury, Judge Cannoni should have called for an evidentiary hearing in which Proctor would have had to testify about when he got the Sally Port video, where he got it from, how long he had it, why it wasn't turned over during the first trial. Adam Lally should have been called to the stand to be questioned about when he got that Sally Port video, how long he had it, why he didn't turn it over. Baker's got the link to the Zoom. And Laura McLaughlin should have been called to the stand. Hold on. Hey, it's bullshit, man. Hang on. Suze, are you here? I'm Suze said she was gonna find it out and give it to me, but hang on. They're talking about something, but I don't even know if it's the Myles King case yet, because it's a man talking. Oh, thank you. Yeah, I don't know. Glamasu said she was gonna send it to me, and the court told me that there isn't one. Hang on, I'm gonna have to call the court again. It's bullshit, man. Hold on. All right, I got it. If anyone is on the Zoom and you're on there, please do not have please mute yourself, because a lot of times people can hear my voice on it, and it is not me. It is people streaming me in the background. Come on, man. Depends on who answers the phone. Is it in courtroom 25? I'll try a different one. You need to calm down.
They're the same look, but it's not the same document. There are additional facts in the stuff that we just got in 2025 that weren't available in 2021. And so what I planned on doing was going through what was introduced in 2021, going through what was introduced in 2025, and pointing out for the court what the differences are in those documents. To refute what the Commonwealth is saying is that they were the same document.
As a practical matter, okay, the two sides or three sides could sit down and do that. And it would eliminate the need for hours of testimony. You could sit down and say, this is a different document than what we got originally. There might be some disputes. Your work product maybe have some mistakes in it. The Commonwealth's work product may have some mistakes on it. You probably resolve 99% of it and put in an agreement that document number 236 was different. Document 237 is the same, but it's got some additional handwriting on it, whatever it is. And that could be stipulated, because that's just a comparison of two different things, right? Looking back, that would establish the baseline for what's new that's been produced in 2025. And then we can talk about prejudice from those new documents.
I understand that, Judge. The other thing that I would ask,
excuse me one second more, it would also focus the analysis on what went wrong in the process. Okay, if all this stuff should have been produced in 2021 or 2022 or whatever, by identifying exactly what's new, we could pinpoint why it happened. Okay, and we get a better understanding of why it happened.
To a certain degree, Attorney Hickman already identified what was new. When she took over the case in January of 2025, she started to do, I think what she called a deep dive into the case. And when she did, she discovered information that wasn't turned over. The way that she produced her discovery notices is she would tell you, I'm giving you a different copy of this because there's a different page. Or she'd say, previously produced on such and such a date. But there's something different about it that she feels like she needs to produce it now. So she's done that in the discovery notices based on her review of the case. She's told us in the discovery notices from April, May, June, I'm sure the July one that's coming, she'll say that either a portion of this or some of it was produced previously. We then go back to those documents, we pull those documents, we look at it, we compare it to what they're giving us now, and we make a determination as to whether or not there's anything new. So to a certain extent, I'm happy to sit down with the Commonwealth to talk about those, but I think Attorney Hickman has done the yeoman's work here in terms of identifying information that was not previously provided to the defense. And she's done that in discovery
Yeoman's
notices that
work.
she's already sent to us. So we've already printed out just the information that she said wasn't previously provided to us.
Okay.
For the court's review, for the Commonwealth's review. But another question that I have, Judge, is if we're going to do this sit down, and I'm happy to do whatever is going to make it easier for the court to make this hearing more efficient and more pointed. But here's the concern I have. In some of the Commonwealth's oppositions to what they've filed here, they've relied on email communications. And we don't have all of the emails that went back and forth in this case. So I'm going to make a request now, Judge, for...
Email between who and who?
So their emails, what they're presenting is emails between that. Trooper Proctor was the main detective assigned to this case. He did all the search warrants. He did all the interviews. He did the arrest. He presented evidence before the grand jury. So he had most of it. So to the extent that there are emails out there between Trooper Proctor and any member of the Norfolk County District Attorney's Office relative to this case, not any other case, just this case, I think that we should at least get access to them. We need to understand the communication that was happening between the Commonwealth. I don't even know that when ADA Hickman took over the case, whether there was a sit down with ADA Lally, whether it was, here's my file, this is what's missing from the file, I didn't get to do these 3 things, could you pick up on that? We don't know any of that, Judge. But I assume that there was communication that went back and forth that I think based on the fact that they introduced the emails, they put them in question. They can't just pick and choose the emails that help them.
Well, I guess I don't understand how they put the emails in question. So I asked about they were emails between who and who, and you're saying they're emails between Proctor and the prosecution team.
That's correct.
Okay, and
I think there's emails that are outstanding, Judge, between different members of the prosecution team, because we have what in essence
different prosecutors taking over. I understand.
Right.
Okay. What do you say?
This is a new request. Certainly requesting work product, and not sure how this is relevant to the issues at hand. And I would ask that council put that into a motion so I can properly respond. I will say that in my opposition, I did, and I filed a motion to impound these. I did provide in Exhibit 1 all of the, just to simply explain the Milton aspect of this, I provided emails from Assistant District Attorney Lally and the Milton Police to help explain the kind of communication that was going on between them, pre-indictment, after discovery requests, and as the case went forward. The third exhibit to my opposition contains information about the jail calls. Again, that was provided in January there were July 21 grand jury requests, subpoena. I would characterize it as work product, communications between Assistant District Attorney Lally and state police about the jail calls. And I made representations of that in my opposition. Relevant to the issues at hand. This carte blanche, I want every email. I don't know how that's relevant. I don't know how that's going to get us to the issues at hand here.
all right.
Without just simply asking for it.
I understand that issue is not yet matured for the court's consideration. Let me ask, I beg your pardon?
I'm happy to put it in writing.
Okay. And we'll deal with it after everybody's had a chance to address it. So is there an agreement that everything that was recently produced is new? How am I going to get my arms around what was produced and how it differs from what was previously produced?
I can say that what I have endeavored in my opposition was to provide it, and they're in table forms. What I asked Assistant District Attorney Lally and ADA Hickman as well to get together on this and provide me with which ones were the same, which of the discovery in 2025 was previously produced in some form. And I tried to articulate where there was differences. For an example, like a video that was provided back in 2021 in a converted format was provided in 2025 in the native format. I tried to identify those to give the court kind of a picture. That's not all that was provided in 2025, but that gives you a sense. As far as a deep dive into the substantive, whether the substantive nature of it is new to Mr. King or Ms. Gardner, I don't know that because I don't know what to them they believe is new. ADA Hickman and ADA Lally provided their discovery.
let's get particular. If you look on page 13 of your opposition, you have a chart.
Correct.
Right? You're comparing notice of discovery 28 to previously provided materials.
Correct.
Okay? And you refer to certain materials bait stamped in the notice of discovery 28. It's a little difficult for me to figure out whether this is entirely new based on the chart or whether it's some similar document or similar information but in a different form or what have you. But take any line, you know, I mean, take Bates number 114 towards the bottom of page 13. I guess it's item 114, Bates number 228 to 232. Milton Police Department incident report is the way it's identified.
Right.
And there's an indication here provided to Attorney John Geary.
Correct.
So it looks to me like you're saying that this document, although recently produced by ADA Hickman, was previously produced by ADA Lally.
To the prior counsel.
To prior counsel, and presumably to this counsel also, because I'm sure all the documents were, all the discovery was reproduced when new counsel came in. So I don't know if there's a dispute about whether item 114 in discovery packet 28 is or isn't different.
Correct.
That's what I'm trying to get my arms around.
I understand that, Judge, and we've gone through those and we've pulled them and we've pulled out the original that we got in 2021, if there actually was an original, and then we'll put it together with what we got in 2025. So we've done that for a number of items in that chart. I think maybe all of the items in the chart, except for the videos. We haven't compared the videos because we'd be here till next year trying to compare the
Well, some of the videos are video clips that were produced originally,
Yeah,
and they've given
absolutely.
you the whole video. And I guess, I don't know if that matters. You know,
Yeah, it could
obviously
be
you now have the whole video. It would have been good if the whole video was produced, but oftentimes there's all 12 seconds in a video that matters. And, you know, it's hard to know whether the
Matters if it was
omission of the entire video matters.
Understood.
So, you know, if I were to go through the first 6 items here on page 13, for example, of Mr. McKee's memo, how do I figure out whether it is or isn't different? I mean, do you also have a spreadsheet that would sort of match up here and describe what's different or what's not? Are you just doing sort of,
Get Richie from Micro.
okay?
We were going to ask witnesses, but now I understand the court doesn't want us to do that. I'm
No,
happy.
you could, okay, you could, but we'll be here until the cows come home. And I don't know when the last time there were cows in Dedham, but you know, bottom line is there probably is an easy way to figure out or to sit down and coordinate what isn't new and what's not, and then figure out whether it matters.
And to this point about, and you mentioned the word matters.
Well, that's prejudice.
Yeah.
Okay, that's whether there's prejudice.
All of the cases cited by both counsel, myself and Attorney Scapiccio, talked about individual documents that were provided midstream in a trial or right before trial or after trial. There hasn't been an articulation of what of any of these documents prejudices the defendant. And I just can't, I've attempted to provide Your Honor with some kind of macro areas that were new and explain them, but I don't know, I can't respond to what I don't know. I don't know which of the documents that were newly provided prejudice the defendant such that the public doesn't have a view of public trial. And that grave an extreme remedy. But since this motion's been filed, the Commonwealth and the defense jointly requested that the defendant's bail be reduced to $2,500. Judge set it at $10,000. He's posted it. The trial is off the list. What I'm trying to understand, and I'd ask the court to order it, is if we're going to meet about, I would like to know which of these documents in a pleading prejudices the defendant, so I can respond to it. I have police here to explain some of these macro issues.
Oh, good.
But I did that almost as anticipatory and trying to help the court, but I don't know even what they're asking or suggesting is prejudicial to the defendant and would prevent him from having a fair trial.
Okay.
So, Judge, I think you're right. There are two issues here. There's their failure to produce Rule 14 discovery, which could result in sanctions other than dismissal. And I think that's an easier question because that's all the notices of discovery that ADA Hickman put together, where she noted specifically, this was not provided before, this was provided before. That's easy for the Commonwealth. It's their document. They gave it to me. So they shouldn't be confused by what they gave me and they identified as new. If they're now saying some of the stuff that ADA Hickman said was new isn't new, then they got to tell me about that, because that's what they had represented and that's what ADA Hickman had represented when she took over. Mm-hmm. So to the extent that we all need to sit down, I'm happy to do that, Judge, but there's two different lines of questioning here. One is, where's the stuff been since 2021? Because my client was in custody for almost 4 years, awaiting trial, and we had a September trial date. And then where's the prejudice? So they're jumping all the way to the prejudice, and we still don't have our arms around where's it been since 2021.
Right. So before I deal with the prejudice issue,
he was in jail for 3.5 years.
It seems to me
How's
that I
prejudice?
ought to know what is new and what you think is materially new. Okay. And I know that puts a burden on everybody to work together, but it seems to me that we ought to do that. I have two other matters on this morning, so we're gonna break by 11:30 today. Okay. I think I can begin by taking evidence on the question of where has this stuff been and why wasn't it turned over earlier. And we're gonna have to adjourn. We're not gonna finish this today. And in the interim, I can have you folks get together and do a comparison to figure out, this is new because it has somebody's handwritten notation in the upper right-hand corner. This is new because it's the full unredacted video, and the redacted video of 12 seconds is the only relevant portion, or whatever, okay?
Did you watch the Karen Reed trial, Judge?
Around materiality, we can get our arms around prejudice, and maybe it will also focus some of the attention on why wasn't this turned over? Because it may be that this is all stuff that was annotations in one person's file. I don't know.
Because this is what they do, Judge.
That's the situation, but it'll focus us a little bit.
Sorry, I can't stop him.
But it seems to me we can use the morning well by beginning on the first question, which is why wasn't this turned over in a timely manner? How do you want to proceed on that score?
I would then call ADA Lally first because he was the first one to touch the file, Judge.
Yes. Call Lally.
I can, it's the defendant's burden. Certainly it's our motion, counsel's motion. I do also have here, just for I have two Milton police officers and state police, Lieutenant Tully, that I would offer the court to explain the Milton aspect and the items that ADA Hickman produced after going to the Milton Police Department and copying paper files and receiving an electronic file from them.
Okay.
That would take care of a bulk of what ADA Hickman provided in the spring of this year.
Why don't we start with ADA Lally? Sure. Okay. And it may be that you also want the talk to the Milton people.
Video.
I'd ask that everybody, all the witnesses, be sequestered, Judge.
Yes. Makes sense.
That's fine.
Okay.
And they've been here all morning.
And
get them all out of the courtroom.
On behalf of ADA Lally.
Sure.
Briefly. Judge Attorney Pat Hanley on behalf of ADA Lally, who's...
Oh, you're near a microphone. You're good. Okay. Go ahead.
Okay.
Give me your name.
Patrick Hanley on behalf of ADA Lally.
Okay.
I had filed, I think, either Thursday or Friday and served upon the Commonwealth and Attorney Scapiccio a motion to limit or perhaps modify the format of any presentation by ADA Lally. ADA Lally is an officer of the court. ADA Lally, I anticipate, is in a position to answer many of the questions that you have or that are raised by defense counsel, but that he should do so from counsel table and address them directly rather than in response to questions. I suggest that it will be faster. He's prepared to do it.
Faster than getting on the stand?
There's follow-up questions that the court has or that are derivative from defense counsel's motion. I suspect that he'll be in a position to answer them. And so I'd suggest that be the format.
Why?
Because it will be faster. It also obviates the need to examine defense counsel to the extent there's any question of what was sent to defense counsel before or what was raised in documents before. Defense counsel, I would suggest, shouldn't be on the witness stand, and he shouldn't be on the witness stand. The last thing I would say is, if the court is inclined to put him on the witness stand, I'd ask for the opportunity to, at the conclusion of defense and Commonwealth's questioning, to question him and raise anything that has not been raised in his testimony by that point.
The motion is denied. Mr. Lally can testify like any other witness. He has relevant testimony. He's being called as a witness, and he can testify as any other witnesses. Lawyers do it all the time. ADAs do it all the time. Defense attorneys from time to time do it.
Sure.
Okay, and so we can proceed.
May I, well, I'll say this. The Commonwealth has filed motions to quash, and one of them partially with ADA Lally. And this goes back to my initial point about narrowing the scope here and focused on the discovery issues at hand. ADA Lally is subject to a protective order on another matter. And I would ask the court to review the Commonwealth's motion to quash and if we are taking a break here and preclude counsel from inquiring about those issues that he cannot testify to and will not.
If there's a protective order issue, we'll address it. Okay, and if he feels like he can't answer a question because he's subject to a protective order in another matter, we'll deal with it.
Thank you.
Okay.
And the other part of this is these were, and I'll just pass them up to Your Honor. These were the subpoenas that both ADA Hickman and ADA Lally received from counsel seeking production. It probably dovetails with counsel's request for all the emails. I would ask that the court quash in so much as the request for the file and any work product and anything that goes beyond Rule 14, mandatory discovery, anything that involves work product, mental impressions, or anything of the such should not be part of this questioning.
So right now, part of this questioning is, what did this ADA know?
Right.
What did he do?
Thank you.
Okay, who did he talk to? That's arguably work product. It gets discovered in this context because the question is, why wasn't this stuff produced in 2021? Mm-hmm. I understand that could be embarrassing for the office. I understand that could be embarrassing for certain individuals. That's where we are right now in this particular case because lots of stuff from 2021 wasn't turned over. Mm-hmm. Okay. So it may be that emails become relevant to this testimony. Okay. Who knew what when and what did they do or didn't do in order to follow up? So I'm going to have to deal with this on a question by question basis. I cannot quash it across the board.
Right? And I would agree, Your Honor. I actually, to that point, I have included emails to explain the issues at hand. So this is not, when I can understand an issue, I provided the emails to help explain it.
Okay. All right.
Thank you.
ADA Lally, you're on.
Yes.
Tell your friends, Lally's on the
come forward
stand.
to be sworn.
I apologize. We have witnesses here. You want them
sequestered? Yes.
So counsel's also, we have a motion to quash this subpoena entirely. ADA Hickman. Do we want ADA Hickman present for this questioning.
They
I
gotta
do
get
not
everybody
judge
else
that.
out.
She's going to be a witness as to what how the condition of the file as she found it. I don't think she should listen to what Lally said he had in the file before she testified. That's no dispersion on ADA Hickman at all, Judge.
I understand. I'm going to overrule the request for sequestration of ADA Hickman. She's counsel of record now and an officer of the court, and I'm confident that we do not need to extend the sequestration order to her. Your objection's preserved. Attorney Costa, to the extent you join in the objection.
I'm joining the objection, Your Honor.
And you have a standing joining of objections if you wish, all defense counsel.
Thank you.
Okay, but others should be sequestered.
All right, get everybody else out.
Are sequestered.
There's Jim. Jim is in the house. Lally's taking the stand. Tell your friends.
You solemnly swear the evidence you give the court in the case now hearing true the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
Thank you.
Good morning, Mr. Lally. In a loud, clear voice, could you please state your name, spelling your first and last name for the record?
Sure. Adam Lally, ADAM, last name Lally.
And what do you do for a living, Mr. Lally?
Assistant District Attorney with the Norfolk County District Attorney's Office
And how long have you worked for the Norfolk County District Attorney's Office?
since 2005.
20 years?
Yes, almost.
What did you do before you worked for the Norfolk County District Attorney's Office?
Started with the District Attorney's Office straight out of law school. Worked a couple warehouse jobs, things like that during.
Sorry,
I worked a few warehouse jobs, things like that during law school. Went to school at night.
Okay. And what school did you go to?
Suffolk.
Suffolk Law?
Yes.
And undergrad?
Undergrad, I went to the University of Southern California.
Okay.
Oh.
And what was your well, at some point, how long were you in the office before you got assigned to the homicide squad? Oh, homicide unit, I'm sorry.
I'm not sure that it's an assignment to the homicide unit. I would say the first homicide that I had outside of the realm of motor vehicle homicide was probably 2015, somewhere in there.
Okay. And let me back up a little. What type of training did the Norfolk County District Attorney's Office offer you in order for you to be able to comply with Rule 14 discovery?
Objection.
Sustained.
So when you started at the Norfolk County District Attorney's Office, you started in district court?
Yes.
Okay. And how many district court cases would you say you tried?
I have no idea. A lot.
More than 100?
Probably.
Okay. And in all of those cases, were you able to comply with Rule 14 discovery and turn over the discovery that was required under Rule 14?
Objection.
Sustained.
Let me ask you this.
She's got receipts.
The hundreds of cases that you tried in district court, was there ever any allegation that you didn't turn over information?
Objection.
Overruled.
No.
Okay. And then at some point you moved to Superior Court. When was that?
Began working on Superior Court cases probably in 2006, full-time assigned to Superior Court in 2012.
Okay. When you say full-time assigned to Superior Court, what does that mean?
So what that means is during the interim period from 2006 to 2012, I had cases in Superior Court, but I was primarily assigned to the District Court.
So you were trying cases in the Superior Court, but you were still trying cases in the District Court?
Correct. Actually, I still do that to this day.
You still try cases in the District Court as well?
I do.
Okay. But you said at some time in 2012, you were assigned to the Superior Court. Does that
Correct.
mean you came here every day?
Correct.
Okay. And what type of cases were you assigned in 2012 when you became a Superior Court DA?
Variety, pretty much ran the whole gamut. Narcotics cases, sexual assault cases, child abuse cases, breaking and entering, armed robbery, whatever I was assigned, that's what I did.
How long after you got to the DA's office did you start trying what they call life felonies?
I don't understand the line of inquiry. Everybody who is in the DA's office is responsible for complying with Rule 14 and is expected to know the confines of Rule 14 and to comply with it. So the backstory here is not particularly useful. What I want to know is what ADA Lally did in this instance.
Understood, Judge. In any event, when were you assigned to the Myles King case? And Brianna Gardner, I'm sorry.
Probably within a day or two.
A day or two of what?
Of the shooting and the murder occurring.
Okay. And how do you get assigned in the district attorney's office? Do they email you? Do they call you? How do they do that?
Objection.
Overruled.
I received a call from the first assistant.
And who would that have been at the time?
At the time, that would have been ADA Lynn Beelan.
Okay. And did she tell you you were assigned to this homicide case?
Yes.
And what does that mean to you, being assigned to a homicide case? What does that mean?
Well, I mean, at that point, it was an investigation. So as far as assisting with the investigation, should charges arise, handling the prosecution from there out.
Okay. So once you get assigned to the Myles King, Brianna Gardner case, is there a policy within the Assistant District Attorney's Office in Norfolk County on how to gather information that's required under Rule 14?
Objection.
Overruled.
A specific policy, not that I'm aware of, no.
Okay, so there's no policy that you're aware of in the DA's office that that details how to gather information. Is that what you're saying?
Not that specific to that, no, not that I know of.
So how do you gather information, and how did you gather information in the King Gardner case that was required under Rule 14? What did you do?
Objection. Just specify what is. It's too vague.
Overruled. Question is, what did you do?
So what I do,
and I think we can take it in chronological order. We'll start at the beginning, and then we'll have follow-up questions.
Sure. So what I do is what I do in every case, depending on how many different departments are involved. In this case, there was a local department and state police involvement. So I would make appropriate requests for any and all information that they had, any information that, you know, specifically I could outline or delineate as far as what I felt was relevant. And
Stop right there. How would you make those requests?
Typically what I would do is write out a formal discovery request, submit the form to any involved departments, and communicate either via phone or email to whoever the relevant party was that I was requesting discovery from.
When you say discovery forms, what do you put on? What did you put on the form in this case for Gardner and King?
Initially, it would be for any and all police reports, any and all photographs, any and all information as to who was present, lab reports, if they had access to fire department, run reports, any lab personnel that responded to the scene, you know, so that I would have an idea as to whether or not there was testing that was going to be conducted or items have been recovered from the scene, copies of any and all search warrants, including applications, affidavits, copy of the warrants, any returns.
Oh, there's Lally. They're showing him now.
Do you have a memory in this case of asking for all the information that you just told you normally ask? Did you do that in the Brianna Gardner and Myles King case? Did you ask for all of that information?
Yes, and just for clarity purposes, when I'm initially doing this, it's not the Myles King and Brianna Gardner case.
It's just an investigation.
Correct.
Okay.
Well, and more to that point, Ms. Gardner didn't become a focus of the investigation until later on.
Okay. So while you were investigating without a defendant being a suspect, at least not initially, you asked which departments for this information?
The State Police, Norfolk County Detective Unit, as well as the Milton Police.
I can't hear you. What's the last one?
Milton Police.
Milton Police. Okay, so you asked Milton Police, you asked the State Police. Who in Milton Police did you ask, and who in the State Police did you ask to send information?
The Milton Police would have been, at that time, Lieutenant Michael Collins. The State Police would have been Trooper Michael Proctor, as he was a case officer, and Lieutenant Brian Tully.
And so you have emails going to all three of them asking for all of the information that you just listed, which would be normal information that you'd ask in any case after a homicide. Is that right?
Yes.
And did let's just take Mr. Proctor, Trooper Proctor, did he respond to you?
Yes.
And what did he provide you?
At varying...
No, to the extent he recalls, he can testify.
It's giving me life.
So at varying times, there were different productions of material, whether it was what was available at that time. So initially it would have been just whatever reports were available at that time. Later on would have been photographs, video.
So how often would you say you emailed or communicated with the state police, and specifically Trooper Proctor or Trooper Tully, regarding discovery in this case?
I cannot tell you how many times via email, but I mean, it was a constant conversation, particularly throughout the grand jury process as far as discovery was concerned.
Okay, so when you say a constant process, was there a time period where you asked for stuff and you didn't get it, so you were re-asking for it, or is it always new information that you're getting from the state police?
I think it would vary. I think there were certainly items that I probably had to ask for more than once, but there were definitely items that I had asked for and was provided promptly, and then moved on from there to either additional information or that avenue was complete.
So do you keep records of, I asked for search warrants, I asked for crime lab stuff, I asked for witness statements? Do you keep records when you receive that information to be able to check off to say, I got these things, they're no longer outstanding, and the rest of this is?
I mean, I keep records in the sense of a list of items I'm looking for, and obviously when I receive something, then yeah, that would get checked off the list as far as I'm not looking for that anymore because I have it.
Okay, so if you got a set of grand jury minutes from a witness that you know testified in front of the grand jury, you'd check that off your list?
Well, as far as yes, I mean, I was at the grand jury, so I know who testified at the grand jury, but as far as receiving the minutes, yes, I'm aware of the dates, and when I received the minutes, then that would check that off the list.
I missed, I think, a question and answer, one question earlier. I think the question was, do you keep records of what you requested? What was your answer to that question?
So records, as far as what was requested, I would always have, at least in some form, some sort of running list of items I was looking for. And then if I received an item, then that would be something that would be off the list. Now that list would be obviously added to as information develops, and there might be additional items that I'm looking for.
And presumably because it's on the list, you've made the request?
Yes.
Okay.
Show me the
And so you'd have, whatever's on the list, you'd have emails requesting that information, is that right?
Yes.
Okay. And then if they emailed back, you'd have checks off of your list that you got whatever it was, that, you know, maybe you were asking for 10 things and you got 5. You'd check those 5 things off your list, is that right?
Yes.
Is there any other mechanism you used to document what you got from, just right now we're talking about the state police, Trooper Tully and Trooper Proctor?
I'm sorry, any other mechanism of doing what again?
Keeping track of what they're producing for you. Is it all just emails and check marks on a list? Or is there some other way that you keep track as well?
Do you signal?
No, I mean, it would be something that I would have a list of items that are outstanding that would be, you know, followed up on if they hadn't been received at that point, and then I would follow up with whoever the appropriate person was to get copies of those.
And these lists remain in the file? Your lists with the check marks remain in the file?
To the best of my knowledge, yes.
Okay. And have you reviewed any of them before you testified here today?
No,
Okay. Is there a reason you didn't review the file before you testified here today?
I don't have the file.
Why?
You work for the DA's office, right?
I do.
And it's in the DA's office, right?
Yes.
And you knew you were going to be asked questions about this case, right?
Yes.
And you didn't do anything to educate yourself about what you did initially on the case?
Objection. This is her witness.
Okay.
Well, I'm not sure I agree with that as an objection, but I'm going to sustain the objection as to the relevance. He did not review the file. Next question.
So what did you review in preparation for your testimony here today?
I reviewed portions of the file. I reviewed some of the items that have been produced by ADA Hickman. I reviewed search warrants. I reviewed police reports. I reviewed, you were asking specifically as far as checklists or notations. I didn't review those, but I did review, I have portions of the file. I have access to the file, and I did review portions of the file.
Okay. So you did review portions of the file? Is what you're
Yes.
saying now.
Oh, yes.
You just didn't review your checklist?
No.
Okay.
The important part.
Now, in terms of the Milton Police Department, do you also have emails going back and forth to the Milton Police Department asking for certain documents?
Yes.
And who in the police, would that be Lieutenant Collins?
Yes.
Anyone else in the Milton Police Department were you looking for documents from?
On this case, I don't believe so, no.
And did you keep the same type of list that you kept for the state police of outstanding things that you were looking for the Milton Police Department?
Yes.
And what did you get back from the Milton Police Department? Do you remember?
Items of similar nature that they had access to, as far as police reports, photographs. I don't believe Milton did any of the search warrants in this case, but
Proctor.
other items of discovery, video that they recovered. That there's a litany of different items.
A litany of different items? Did you
Yes.
say? Okay. And those would all be memorialized by email? Is that how you did it?
Yes, that's, I think, what Mr. McGee attached as Exhibit 1. It's about 137 pages.
Of emails back and forth between the Milton Police Department and you?
Correct.
And so at what point do you know that you have all of, so other than, strike that, Milton Police, State Police, any other person or entity that you sought information for in this case?
Certainly.
I'm sorry?
Yes.
Who's that?
Be the Office of the Chief Medical Examiner, be the State Police Crime Lab. There were some items that were outsourced to Bodie Technology Lab in Lorton, Virginia, where they did some additional forensic testing pursuant to DNA. They have different methods that our lab does not.
They use Bodie a lot, huh? It's their go-to.
Milton Fire Department, I believe Fallon paramedics were involved in the transport of the victim, Mr. Simmons. That's all I can think of at this point.
Okay. And would you communicate with those agencies the same way you communicated with the State Police and the Milton Police via email?
For the most part, could have been a phone call on some of those.
All right, so let's stop there. If there was a phone call, how did you memorialize what you requested and what they said in a phone call?
Notes.
You have individual notes?
Yes.
And where would those notes be right now?
In the file.
He's got notes.
So do you keep like a running page of all the notes that you've taken in the case with communications that you had with all of the other entities and officers in State Police in this case?
Not all in one location, but it would be sort of divided up by different entities as far as what I was requesting from that specific entity and what I was looking for, what I was still waiting for, what was still outstanding, things of that nature.
This is what Cannoni should have done. Made him take the stand in Karen's
What happens
case.
when you ask for something, let's just say from the State Police, and they don't give it to you? What's the next thing you do?
The next thing I do would be to ask for it again.
Okay. How many times do you ask for it before you have a meeting with the State Police to look at their file?
Objection. The biggest objection I have here is that we're not speaking about any individual document, any individual date, vague questions about
this is general practice, generally Mr. Lally's practice. I think part of the issue here is we don't have very specific items that are being referred to, but I think I'm going to overrule the objection and give Attorney Scapiccio a little bit of leeway here in terms of general practice.
Good.
So in general, how many times do you email for the same document before you go to the State Police and start to have a sit down with them?
I think it varies. I think it would be depending on a lot of different factors as far as what the item is, what the explanation is for why I don't have it yet, whether it's not available or whether it's something that they're currently working on, or if it's something that I know has been completed and I've asked for it multiple times and I still don't have it. I'm not saying that even happened in this case, but if in a general practice, if that were something that were going on, then yes, I would want to sit down with somebody and figure out exactly what's going on.
If they had to invert the video before they gave it to you?
Questions about this case. When you reached out, let's start with Trooper Proctor, in this case, looking for information, and there were emails back and forth. Were there any occasions where you did not get the documents or the information that you were seeking from Trooper Proctor?
I don't recall anything specific other than if it was a situation where I'm looking for a report about something and that report hasn't been completed yet, or that item hasn't been obtained yet for whatever reason. But I don't recall in this case ever asking for something and just not getting it.
Do you remember asking Trooper Proctor for the search warrants that he did in this case?
Yes.
And the affidavits accompanying the search warrants?
Yes.
And did he provide them to you?
What I received was a partial affidavit for search warrants.
Did he provide them to you, yes or no?
Some.
How many search warrants do you recall there being in the King Gardner case?
In 2021 or beyond?
2000, let's start with 2021. How many search warrants? You guys pulled the search warrants?
6.
Partial.
When you asked, and he signed all 6 search warrants, is that fair to say?
That's my understanding, yes.
Okay. And so when did you ask Trooper Proctor for the search warrant?
In July or August of 2021 when they were filed for.
Okay. And when did you get all 6 search warrants from Trooper Proctor?
I didn't get all 6 search warrants from Trooper Proctor.
Oh.
You did not?
I did not.
Okay. So did you get 1 search warrant from him?
From him specifically, I received a portion of the affidavit for search warrant 306 and the entire affidavit for search warrant 348.
Oh, 1.5 out of 6.
Okay. So you got portions of 2 search warrants and you knew there were 6 search warrants. Is that right?
Yes.
Did you make notes somewhere in your file? Geez, I asked Trooper Proctor for these 6 search warrants. He hasn't given them to me yet?
I believe, yes.
Okay, those notes are in your file?
I believe so, yes.
Okay. And then when you didn't get the search warrants from Trooper Proctor, did you meet with him?
Yes, I mean, specific to that, I don't recall any specific meeting related to search warrants, but we did meet several times in relation to this investigation in this case.
But you understand that search warrants are Rule 14 automatic discovery, right? And you knew there were 6 search warrants, right?
I did.
And so when do you realize that you don't have all 6 search warrants? How long into the process? Do you know right away you don't have them all? Or do you not know for a long time you don't have them all?
I don't think I realized at that time that I didn't have them all.
So how, then I guess I'm confused about how your system works. You said you had a system where if you asked for something and you didn't get it, you would then follow up with the police officer asking again and again. Did you do that with Trooper Proctor in this case with the 6 search warrants?
Yes, I believe so.
How many times did you email Trooper Proctor asking for the 6 search warrants?
I don't know.
More than 10?
No.
I don't believe so, no.
Okay. How far in between each email? Did you wait a month and email him again? Did you wait a week? Did you wait a day? How long in between your requests to Trooper Proctor to produce the 6 search warrants in this case?
I don't know.
I don't know.
You don't?
No.
Did you review your emails before you came here today?
Some of them, yes.
Some?
Did you see any emails to and from Trooper Proctor regarding the search warrants?
Yes.
How many did you see?
I don't recall.
More than 5?
Yes.
More than 10?
I don't know.
What are the dates of the first time you asked Trooper Proctor for the search warrant?
Specific date, I don't know.
How long before the next time you asked him for a 6 search warrant?
Specifically, I don't know.
Was it months or weeks?
Weeks.
Weeks later. Okay,
Yes.
so that's 2 times you asked him. What about the third time? How much time went by?
I don't know.
Months or weeks?
I don't know.
I don't know.
What about the 4th time?
Again, I don't know how many times and I don't know specific dates.
So I guess my question is, how does your system work if you're not getting the discovery that you're asking a police officer for, and you're asked for it, let's just say 5 times? What do? Do you go to the office and you sit down and say, give me these search warrants, I have to turn them over?
Yes.
You did?
Yes.
Did you do that in this case?
Yes.
You go to Trooper Proctor and say, give me the search warrants because I have to turn them over.
Yes.
When did you do that?
Sometime prior to the defendant's arraignment in December of 21.
November of 21, did you say?
December of 21.
December of 21. So when you get to his office, do you go there or do you tell him to come to your office? I don't know how that works.
Either way, I don't
Remember how you met about the search warrants the first time?
In
other words, did he come to you or you go to him?
I don't know.
Okay. So you have a sit down.
Yes.
And you ask him for the 6 search warrants, and what does he say?
He will get them to me.
He will get them to you.
Yes.
Okay. If you tell him I have an obligation to turn this over because it's Rule 14 discovery, I need it right away, I've asked for it 5 times, what's the deal?
Those specific words, no, but the gist, yes.
Well, tell me what you said specifically.
I don't know.
I don't know. How about I
Well,
don't
give me a
recall?
best estimate of what you said to Trooper Proctor after you asked 5 times the
Objection.
search warrants that he didn't turn over.
Sustained.
So did you keep any notes of your conversations with Trooper Proctor when you were asking for these 6 search warrants that he didn't give you?
No,
Why not?
it was something that I knew that was outstanding. It was something that I had asked for in written form numerous times. I didn't feel the need to write a note that I asked for it again.
So that's the first sit down. Did you send emails after the first sit down saying, hey, you promised me you're going to send these 6 search warrants, I still don't have them?
Objection, assuming facts.
Overruled.
Sorry, could you repeat the
Did you
question?
send another email to Trooper Proctor after you had the sit down at sometime in December of 2021 saying, hey, you still didn't send those 6 search warrants, can you send them over?
Yes.
How far after Mr. King's arraignment in December of 2021 did you send that email to Trooper Proctor?
I don't know.
Was it a year?
I don't think so, no.
What do you think? What's your best estimate of when you sent that email after you sat down with Trooper Proctor?
I would say probably a few months later.
All right, a few months.
Yes.
So February, March of 2022, is that what you're thinking?
I don't recall specifically.
So when you're in this room with Trooper Proctor asking about the 6 search warrants, do you ask him for his file? Like, give me your whole file so I can go through it and figure out what's in it?
No.
Why not? You're there. There's outstanding discovery. You have the obligation, not the police officer. Why don't you ask?
I entrusted that whatever discovery I was requesting, I would get at some point in
Proctor?
a timely fashion and then turn it over.
But you didn't get it. You asked for it 5 times. You didn't get it. You had to go see him. You have them right there now, and you still don't say, give me your file? Let me go through it?
No, I did not.
And when he says you'll get the search warrants, I'll send them to you. Did he have them? Did he have copies of the search warrants? He just wasn't giving them to you?
That I don't know. You'd have to ask him.
Oh, we will.
Well, you don't get the search warrants in any event after that sit down, and you send another email. What's Trooper Proctor's response to that email?
Again, I don't know that I sent another email, but I know that there were subsequent conversations about it. Whether it was what format it was in, I don't know.
Okay, and at this point, you have to be getting a little upset with Trooper Proctor that you're asking for information that he's not giving you, right?
Objection.
Overruled.
I'm sorry, your question again?
You have to be getting a little upset at Trooper Proctor that you're asking him for information that he's not giving you, right?
I would say upset, frustrated probably.
I'm sorry?
Frustrated probably.
Ooh.
Oh. Judge, can we approach sidebar just briefly?
Yeah.
I know.
Sure.
Sure. He's getting frustrated with Proctor. Proctor's not turning stuff over. He got 1.5 search warrants out of 6 because you know what? Proctor's hiding shit again. And this is before the Karen Reed case. This is in 2021. Proctor's got a history of doing this. We're finding out all about it. Karen Reed is here. She's in the chat. She was anyway. And you can bet your ass, maybe if they're not busy, Alan Jackson, David Yannetti, Bob Alessi are all watching this too, because this is how they do things. He is showing you the custom and practice of the Norfolk County DA's office going back at least to 2021. This is what they do. This is how it works. I keep notes. He doesn't give me what I want. I keep asking. I get frustrated, but I don't keep track of all the times I had to ask Proctor for shit. He's not going down with this ship. He's going to throw Proctor under the bus. This is the way it happens. This is the way it works in Norfolk County. And you are listening to Adam Lally telling you that in real time. Thank you, B. Crumbs, for gifting 5 memberships. This is the best Monday I've had in a long time. We've been waiting for this. This is what Judge Cannoni should have ordered: an evidentiary hearing in the Karen Reed motion to dismiss for egregious governmental misconduct, because now we know they've been doing this since at least 2021. And you can bet it goes back decades. Tully's got his hands in everything. He's there today. The ADA is going to put him on the stand. Proctor is there today. Adam Lally showed up with an attorney who tried to quash this subpoena or at least limit it. And the Judge Krupp isn't having any of it. He's like, no, you're going to take the stand. We're going to decide on a question by question basis about what he doesn't have to answer. But yeah, you're not going to just quash the whole subpoena. His attorney is Pat Hanley. I don't know who that is, but let's find out. Wonder if he's like if he's part of the Norfolk County DA's office. Imagine what a different trial it might have been if Judge Krupp had overseen the Karen Reed trial. Imagine. Just imagine. Rosemary Scapiccio is my spirit animal. She's asking all the right questions, and her sarcasm is on point, and karma is coming for them. Thank you, Bev's Dizzy Glasses. Cleverly twisted says all love and prayers for you, Karen. Thanks for your 5. Victor Mann, thanks for your 10. Wow, the defense is allowed to question a witness and all objections are not ruled in favor of the prosecution in Norfolk County. Right. Same courtroom. This is courtroom 25 where Karen Reed's trial was held. The little tiny courtroom. And they still have the curtains. They still have the curtain. We can't see it right now. It's not in frame right now, ShamWow, but he can see it all the way from Canada. eBay Warhol. Someone needs to pull Miss Beeland out of retirement. Oh yeah, she left skid marks when she left the DA's office. Remember all of those frantic emails she was writing to Josh Levy, who was the acting U.S. Attorney of Massachusetts at the time? Oh, thank you, Melinda. Melinda is telling me more of a lessee. I think I previously heard an attorney say squash, not quash. No, there's no squash. It's quash. I think he did say quash. Thank you, more of a lessee. And Michelle said if they would have provided the whole video first, this conversation would be moot. The defense can decide what 12 seconds matter. Yeah, were they editing video, inverting video in this case too? This is how they've done it unchecked for decades. I've been screaming about this since I started covering Karen Reed's case in January of 2024. And this is wild. And Patrick Hanley is appointed to the state.
In any event, ADA Lally, a couple of months goes by, you still don't have the 6 search warrants. What do you do?
What do you do, Lally?
I don't know. I mean, I specific to the 6 search warrants, I don't recall as far as there was a topic that was discussed repeatedly. Obviously, I never received them because I never provided them to you or to Ms. Costa.
Wow.
Okay. So I guess what I'm saying is you knew they existed and you knew that, let me just say this, you knew that all six search warrants existed. Is that right?
Yes, we went through all six of the search warrants on the last day of the grand jury presentation on November 19th, 2021. But that's in the grand jury minutes as far as going through each of the materials, each of the search warrants, that they were search warrants, how that material was obtained, and the material that was returned in response to 3 of the search warrants was marked as grand jury exhibits 33, 34, and 35.
But you just didn't have
them.
Correct. Well, no, actually, I'm sorry.
Information in front of the grand jury about 6 search warrants that you hadn't seen, and you put returns or information that had been returned in front of the grand jury on search warrants you had never seen.
So with
Answer that question.
And I'm trying to. So
Okay.
with regard to those 3 search warrants, that was 306, 307, and 329, which were the call detail records for your client, the victim, Mr. Simmons, and Mr. Jeanette. The materials also that came back from the cell phone providers also contained a copy of the warrant, as well as the addendum to the warrant, which was then also provided to you and Ms. Costa in discovery.
But not the warrants themselves.
No, the warrants themselves and the addendums, not the application and not the affidavit.
Right. So you understand that in order to make a determination as to whether or not you're going to suppress certain information, you actually need what you asked for and what you, in the affidavit that told the clerk magistrate why you had probable cause, right?
Objection.
I can take judicial notice of that, and I'm sure Mr. Lally knows that.
Okay. So you get in front of the grand jury. When do you present this case to the grand jury?
Began in July of 2021. That grand jury sat in July, August, and September. The presentation had not been completed at that point, so there was a motion to extend the grand jury. And I believe there was one subsequent date that we went before them on November 19th, 2021.
November what?
19th, 2021, that's when indictments were returned.
He remembers all that.
2021.
He remembers
Correct.
those dates, but not the emails or the warrants.
So at some point when Mr. King is arraigned, you understand at that point, Rule 14 kicks in, right?
Yes, I mean, I'm thinking about Rule 14 well before that.
Okay. And you know, when you arraign Mr. King, you still don't have the search warrant. You have another conversation with Trooper Proctor about, hey, where are these search warrants? I have to turn them over.
I'm sure I did.
And do you know when that would have been?
I don't.
Okay. And then, remember at some point in December of 2021, receiving a discovery notice from me. Hey, Brooke, what are you trying to?
Yes.
This is just my discovery notice.
There's Rosemary. We love her. You're a pistol girl. Set the place on fire. Burning down the house.
That a discovery motion or what is
Motion,
that?
I'm sorry, motion, Judge.
The roof. The roof.
Yes.
Okay. And do you remember, after having filed this motion, you asked the time to go through and make sure that you can comply with all the requests, right?
Yes.
And you didn't have any specific objections to anything that I was asking for, right?
At that time, no.
Okay. May I approach the witness, Your Honor?
Yes.
Sorry, Judge.
Is that an exhibit? Is that a docket entry?
It is a docket entry, Judge. I can,
Do you know what it is?
I think it
Or we can mark that just so that there's a record of what you're showing the witness?
has my writing on it, Judge. So
All right,
I want to
so-
mark it. But I'll do it after the hearing. I'll find the exhibit and I'll make a clean copy and send it to the court, Judge. So once you get the discovery notice, you know for sure that there are certain categories of information that we're looking for, right?
Yes.
And number one is all automatic mandatory discovery under Rule 14, right?
Correct.
Would you consider those search warrants automatic mandatory discovery under Rule 14? Okay. And we were looking for any and all statements of witnesses, is that right?
Yes.
And we were looking for all exculpatory information, whether
The
tangible.
document speaks for itself.
Okay, that's fine, Judge. So after I filed this motion to December of 2021, you have another conversation with Trooper Proctor saying, give me the 6 search warrants.
I'm sure I did. My general practice is if there is any discovery motion that's filed by counsel, what I'll do is I'll send that to the appropriate police personnel as far as making requests and making sure that they're apprised of what's been at least asked for.
He sends it to the cops?
And did you do that in this case? Did you send my motion for discovery to Trooper Proctor,
Tully.
to the Milton Police, to the crime lab, to the medical examiner's office? Did you send it to all of those entities?
Every motion that you filed, yes.
Okay. And then what do you do to follow up with each of those entities? Let's start with the state police. They get a copy of my discovery motion. You're looking for all of the evidence that they have, and specifically these 6 search warrants that, for whatever reason, Trooper Proctor hasn't given you. When you follow up, how long does it take you to follow up from the time that you give them the motion until you get an answer from them?
Specifically, I don't know. Typically, I would give it a couple of weeks or so.
And after a couple, and in this case, did you give it a couple of weeks, you think?
Probably.
Okay. And then what happens?
And then I'll follow up again.
When you say follow up, do you send another email or do you get in your car and drive down there and say, we got to end this, give me this stuff?
We gotta end this.
Email or a phone call.
Okay. And so did you email or phone call, or make a phone call to Trooper Proctor in this case?
I'm sure I did.
And what was his response
I don't
when you
recall.
asked for the 6 search warrants?
I don't recall.
Well, do you have any notes of your conversation with him? Remember you taking notes?
I don't believe so, no.
Is there a reason that you didn't take notes when you spoke to Trooper Proctor after these search warrants had become an issue? That you wouldn't take notes of what Trooper Proctor told you about the search warrants?
So you're asking me about a conversation that I don't recall specifically when it happened or exactly what was said. So whether or not I took notes for that conversation, I don't know. What I would do typically in my general practice is to follow up with whoever I had outstanding discovery requests in relation to try to get whatever information that I was seeking.
Okay, and so did you follow up with Trooper Proctor about the 6 search warrants?
I'm sure I did, amongst probably a number of other items.
That he didn't turn over.
And then you knew the case was going in for another date on discovery, right?
Yes.
And you knew you'd have to answer to the court what you've provided and what's outstanding. Isn't that typically how it goes on discovery dates?
Yes.
Did you ever tell the court, geez, I have these 6 search warrants that Trooper Proctor has, I can't get my hands on them, can you issue an order or can you help me out here?
Did I do that? No.
So when you went to court, do you remember representing to the court that discovery was ongoing and that you were producing as much information as you could? Remember that?
Typically, that's what I would say if that was the case, yes.
Okay. But you knew when you represented that to the court that you didn't have the search warrants, right?
Yes.
So what was your plan? How are you going to get them?
As I stated, what my practice would be if there was some outstanding item of discovery, I would request it and follow up if I hadn't received it.
But you did that. You requested it 5 times. You went to see him. Then you got my discovery motion. You sent that to him. You waited another month. And then what happened?
No.
I don't recall.
Well, don't you tell him, get me these things now. I'm coming down your office?
Objection.
Overruled.
Did I ever tell him that? No.
Okay. So what do you do when he's not complying with your request? Let me ask you this. What's the policy in the office of the District Attorney's Office in Norfolk County when a state trooper is not complying with a request for discovery?
Objection.
Overruled if there is a policy.
Yeah.
What's the policy?
I don't know any specific policy related to that.
Okay.
We don't have policy.
So do you go to your supervisor then and say, hey, I've asked Trooper Proctor 5, 6, 7 times for these search warrants. I've been down to see him in person at least once. He's not giving them to me. What do I do?
No.
Did you ever have another case other than Mr. King and Ms. Gardner's case where a state trooper didn't give you search warrants that you had been asking for since before indictment?
Karen
Objection.
Reed.
Overruled.
Karen Reed. Overruled.
Not that I recall, no.
Okay.
Your Honor, may I be heard on one slight issue? The discovery, the discovery request the counsel is speaking to, I don't believe that it was ever docketed. I don't have a copy of it. I've never seen it. So
The motion, the motion?
The motion for discovery was filed. He got
it may not have reached the docket. As I guess
I want to make sure that you see it, though. Let's make sure you...
Speaking about it a lot here. And
No.
I've never seen it.
Attorney Scapiccio, can you just give it to Mr. McGee for a second?
Mr. McGee.
You think it would be in the file?
I would think it would be in a file.
Yeah.
Is that a clean copy?
That is a clean copy, Judge.
Can we mark that? Should we mark it?
It's unsigned and it's probably, I don't know if it's a draft or a,
Oh, the non-signed. All right, so let me get you a signed copy, Judge.
I don't know what was.
The bottom line is this witness said he received it, Judge. I know I wouldn't have not filed it. We talked about it in the hearing. And I think there is a transcript, Judge, of a hearing where we talked about the discovery motion and the court had it.
All right, we'll figure that out.
You guys get the transcript?
Wow.
We do have ADA Hickman did have a copy.
You do have a copy?
I never saw it on the docket. I was working right off the docket.
Okay.
So,
And just so the record is clear, we have marked it? You want it marked as Exhibit 1 in this hearing?
yes, Judge.
Sure.
All right.
Get you a signed copy of Carol's.
All right. That will be Exhibit 1.
Thank you. I'd also,
This is
at some point,
outrageous.
Judge, like to mark the pretrial conference report.
You should be
in this case.
outraged.
Thank you.
So this had never happened to you before, Attorney Lally, and you didn't go to Lynn Beelan, who was your supervisor, and ask her what to do. What was your plan? How were you going to solve it?
I don't recall specifically having a plan. If there was a situation where I was asking a trooper or a case officer for something and I had not yet received it, I might get that person's supervisor involved as far as
Tully?
saying I've asked for this a few times, I don't have it.
Okay, so let's stop there. Trooper Tully was Trooper Proctor's supervisor, is that right?
Yes.
Did you go to Trooper Tully and say, hey, I don't know what the deal is, but I can't get these 6 search warrants from Trooper Proctor. Can you have him send them to me?
Specifically about the search warrants, I don't recall.
You didn't go to a supervisor.
I don't know if I did or I didn't.
But as you sit here today, you don't remember going to a supervisor, is that right?
I know that there were a number of meetings in relation to discovery that Lieutenant Tully was present for, along with Trooper Proctor, but going specifically to his office to demand 6 search warrants, I don't recall that.
Tully's in the hall. He's going to be asked. And he better not be watching my show. Tully, turn off your
How much time
phone.
goes by before you ask for the search warrants again?
I don't know.
Is it a year?
I don't know.
During the time period, it's fair to say that we were appearing in court every couple of months on discovery, right?
Yes.
Did you ever notify the court on any of those court appearances that you were having trouble getting custody of the 6 search warrants that were issued in this case?
No.
Okay. Now,
thank you, Susie Q, for gifting
you
10.
talked about having meetings, discovery meetings. Tell us what those are.
You know, at various points, probably more towards the early stages, or if there's something that's significant that comes up, it would be just a meeting in relation to, this is the discovery that's outstanding, this is what I'm looking for, what's the ETA on this, when should I expect to receive this?
And are those meetings in person or on the phone?
Typically in person.
And do they take place at the DA's office or at the state police?
Well, I mean, in this specific instance, the state police is attached to the DA's office, so it's the same building. So whether it was my end of the hall or their end of the hall, I don't know.
Okay. And do you remember discussing the search warrants and the outstanding nature of the search warrants at the first discovery meeting?
Yes.
And what was the response?
That the search warrants are still ongoing, as some of those search warrants were not just July. I believe it continued into probably September of 2021 as far as the last of the search warrants. I could be off on those dates, but
You knew the exact dates of the grand jury.
How many
Selective memory.
motions, or how many meetings do you have regarding discovery before the return of the search warrant in July of 2021, if that's the date?
not many. I mean, the murder occurs on July 10th, so there's not a lot of time in between that. So probably 2 at the most.
2, okay. And you don't take any notes on those meetings either?
I don't know.
But I guess I can't figure out, how do you keep track? If you have this list that says all these things are outstanding and you're having these meetings because there's things outstanding, if you're not taking notes at these meetings, how do you know what people are saying and when to expect a discussion?
So if there was something that specifically was known as far as, this is what's going on with this piece, and anticipated sort of ETA on return or something, then yeah, there would probably be a note about that.
All right, so let's assume that the returns came back the latest July of 2021. Let's give you 3 months, August, September, October. October of 2021. Are you asking again for the search warrants that you still don't have?
We've been over this time period. I'm trying to figure out you went all the way through arraignment and on the number of meetings and emails back and forth. I get it, but maybe you want to cover new ground.
I'm just trying to figure out, so let me ask the question. So
Get him to lie a bit more.
when do you realize that you never turned over the search warrants? When do you realize that?
As far as the 2021?
Back up. When do you get the search warrants in your custody?
In my custody?
Yeah.
Never.
I would say probably I became aware of it about a month ago.
In 2025?
Yes.
July of 2025 or June of 2025?
What?
Yes.
Is the first time you became aware that you didn't turn over the search warrants?
Yes, if I had been aware earlier, then I would have turned over the search warrants.
4 years later.
But you had your list, right? You had your list that said 6 search warrants outstanding, right?
Yes.
You didn't ever check that off, right?
No.
So you knew they were outstanding, right?
Yes.
Okay. And then
He was in jail for 3.5 years waiting for his trial, this
when
guy.
did they get to your file?
Again, so as far as my file, they did not. Again, I became aware of it after the case had been transferred from myself to ADA Hickman.
Well, let's talk about that. What date was the case transferred from you to ADA Hickman?
I'd say probably somewhere in October or November of 2024.
2024.
Yes.
And how does a case, let me just say in general, how does a case get transferred from one DA to another? Is there a policy within the Norfolk County District Attorney's Office of what needs to get done to transfer a file?
No policy, no.
Okay.
After
So what did
Karen
you
Reed's
do in this
mistrial.
case with Mr. King and Mr. Gardner to ensure that your complete file got in the hands of ADA Hickman?
So I physically took the physical file from my office to ADA Hickman's office.
Okay. And do you have a conversation with her?
Yes.
And did you tell her, hey, there's 6 search warrants that I was never able to get from Trooper Proctor?
Again, if I had known or remembered that the 6 search warrants were still outstanding,
Oh, you
then I would have
remember?
got them and provided them. So no, I did not reference that specifically.
No
But then at some
sidebars.
point, ADA Hickman has to come back to you and say, did you not turn over these 6 search warrants? Say that to you?
No.
She never did.
Nope.
Never to this
Did you
day.
have a conversation with ADA Hickman about the outstanding 6 search warrants?
Not until recently, no.
Okay, and what transpired?
Objection.
Sustained.
Well,
Her name's Jennifer Hickman, the
So-
ADI they're talking about.
when you told the court that discovery was almost complete, did you know when you made that representation that the 6 search warrants were still outstanding?
Objection.
I don't know what time frame we're talking about.
I also, as I've stated in my opposition, I've reviewed the FDRs on this from December and February and the other dates in 2025. That statement was never made. So,
That's
and
why
then
I want a
December
date. That's why I want a date.
and October as well, when Your Honor set this for trial. So thank you.
You're welcome, Stella.
So, when's the last time you remember answering on this case?
I believe it was December of 2024.
Could it have been January of 2024?
January 2024?
Oh, so let me back that up. In January of 2024, were you still representing the Commonwealth?
Yes.
Okay. And do you remember there being a hearing regarding discovery?
Not specifically, but I'm sure there
Okay.
were.
And do you remember, excuse me, do you remember
I think she means
the court asking
2025.
about discovery and how the discovery was proceeding?
2025,
I'm sure
Rosemary.
it happened. I don't recall that specific date or what was asked.
Okay.
Cannoni was the judge then. Cannoni was the judge. I think she means 2025.
And do you remember telling the court in January of 2024 that you were hopeful that by March of 2024,
There was
we
also
could
one in
proceed
January.
forward because discovery would be complete? Remember that?
I don't.
Okay. May I approach the witness?
Yes.
There was a discovery hearing in January 2024, a compliance, and also one in January 2025.
2024.
January 25 was a discovery motion in front of Cannoni. January 24 was a compliance hearing about probably complying with discovery.
May I approach the witness?
Yes.
I'm going to give you the transcript of the appearance before this court on January 24, 2024, and ask you to look on page 5 and tell me, read that, the bottom of page 5 to yourself and the top of page 6.
She's telling them everything. He probably represented to the court that discovery's done. You can't make this shit up. Welcome to the accountability party. Thank you, Shannon.
Yes.
Does that refresh your memory as to whether or not in January of 2024, you told this court that substantially discovery was complete? There might be 1 or 2 items that are outstanding, but can we get them to us?
I didn't read that portion. I was reading the highlighted portion, if I could have a moment.
Yeah, take all the moments, Lally. Lally flop, ooh, lally flop. I miss that song. The walls come crumbling down. The dominoes are starting to fall. He was also lying to the court in the Karen Reed case.
I'm sorry, I'm not seeing
January
what you're
2024.
referring to in that
Well, do you remember
transcript.
telling the court, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that to the court?
I may have.
Look at lines
Read it.
16, 17, and 18. on the document that's in front of you, Ms. Lally.
And what page, Ms. Attorney?
Page 4, lines 16, 17, and 18. The court asks, where are we, Ms. ADA Lally? And you say, Your Honor, I think as far as discovery goes, we're in a fairly good position. Did you say that?
Again, I'm sorry. In the transcript that you handed me, I don't see that.
Let me see. Here's a different one.
Thanks, Duncan. She's got receipts. A year and a half ago, he's telling the court discovery's nearly complete. She's got
Do you remember?
Transcript from
Hold on, let me get this right.
Yep, Snarktank says he knows he's going to get grilled about not turning over information, and he leaves the file at his office. Just the usual. Just the usual.
Do you remember
Thanks,
telling
Kelly.
the court, I was wrong, you were right. Do you remember telling the court there may be a couple of outstanding pieces, talking about discovery, that I'll check on, and some other pieces that I was speaking to Ms. Proctor about, but I think hopefully that by March 11th date, we should be able to proceed forward. Remember saying that to the court?
Do I remember saying that to the court? No.
Does reading that refresh your memory that you said it to the court?
I didn't read that portion. On what page are we on?
Yes.
You can read from here over to here.
Okay.
Yourself, please.
Sure.
Rosemary Scapiccio is fire. Lori says, karma, this is what happens when you frame an innocent woman and let killers go free. This was before the Myles King case happened in 2021.
Yes, that's correct.
Does that refresh your memory? ADA Lally, that you indicated to the court that, get this exactly right, there may be a couple of outstanding pieces that I'll check on, and some other pieces that I was speaking to Ms. Proctor about, but hopefully by the March 11th date, we should be able to proceed forward. Did you say that to the court?
Well, those are two. So does it refresh my memory? No, but according to that transcript, that's what I said, yes.
Okay. And you know at that point that there were still 6 outstanding search warrants that you didn't have?
No, again, if I had known, then I would have gotten them and provided them.
Mr. Lally, you
Okay.
having memory problems, Mr. Lally?
Weren't we talking about search warrants on this day?
You're talking about 2022 search warrants, which were in a subsequent notice of discovery related to a cell tower dump. You were provided all of those as far as the application, the affidavit, the return, and copies of the warrants themselves.
So we're talking about search warrants.
Separate search warrants, yes.
And nothing's ringing the bell that you didn't turn over 6 search warrants?
Apparently not.
Apparently not. No big whoop, no biggie. We do it all the time.
So the 2022 search warrants that we talked about in court back on January 24th of 2024. At that point, Mr. King was indicted. Is that right?
Yes.
Was Ms. Gardner indicted?
Yes.
All right. So what process did you go through to issue the 2022 search warrants after indictment?
Through this court.
I'm sorry?
Through this court.
So you went to Superior Court and asked for these search warrants. Is that right?
Myself personally, no.
Well, did you notify defense counsel that you were asking for search warrants in a case where a client had already been indicted?
No.
Do you know whether or not there's an obligation on behalf of the district attorney's office to notify defense counsel post-indictment if you're moving to request additional search warrants?
They weren't search warrants that were pertaining to the defendants. They were.
Do you know whether or not there is an obligation on behalf of the district attorney's office, you specifically, to notify defense counsel if you're seeking search warrants after indictment?
Objection. If this is a legal, yeah.
Sustained.
Thank you.
He's a lawyer.
So in any event, we're talking about search warrants in January of 2024. You don't say anything about the search warrants that are still outstanding, those 6. And you tell the court there's only a few things that are outstanding then. Is that right?
Yes.
Okay. And then we come back, we suggest March, and we come back in March. Is that right?
I believe so, yes.
Okay. Then in March, do you tell the court, Your Honor, as far as discovery goes, we're in fairly good position. In regard to that, I believe that was turned over just prior at the last date, so there may be a couple of other additional items of discovery that I need to get and turn over, but otherwise, I think we're in a fairly good position. Did you say that to the court, sir?
Again, I don't.
Finish, Your Honor.
Yes.
Fairly good position. He says this all the time. We heard it a
These
million
transcripts
times.
in the FTR, what's on the FTR, what was said by whom,
Karen
when,
Reed's trial.
is all a matter of public record, and we can look at the FTR and get
Is
it.
it?
So specific quotes
Public
and what
record?
was said, what was represented, that's part of the record, and we can see
But I
that.
just have to set it up so I can ask the question that I want to ask, Judge.
Great.
Thank you. So after having made that representation to the court, did you do anything to get the 6 search warrants?
No.
What were the outstanding matters as far as you understood back in March of 2024?
I don't recall exactly what we were talking about on a court date in March of 2024.
Do you have any notes that would refresh your memory as to what was outstanding at that point?
I might.
Where are they?
And would they be in your file?
If they were anywhere, that's where they would be, yes.
Okay.
He really
Now-
doesn't care. He doesn't care.
Other than the discovery motion that we filed, did we also file a pretrial conference report in this case?
That I don't recall.
Okay. But you understand normally we file a pretrial conference report where you agree to give me what I'm asking for and we agree to file motions on stuff we can't agree on. Is that typically how it goes?
Yes.
Okay. And you don't remember signing a pretrial conference report? Not that you didn't, you just don't recall.
I don't
Show it to
recall
him.
every pretrial conference report I've signed.
Okay. And then we talked about the meeting with the state police. Did you have any meetings with the Milton police regarding outstanding discovery?
In-person meetings? No.
Did you send the Milton police the same type of discovery request that you would have sent to the state police?
Yes.
And did you follow up with the Milton police the same way that you say you followed up with the state police?
Yes.
And did you follow up specifically with Lieutenant Collins?
Yes.
And so what in your mind was outstanding on the Milton discovery that you were communicating with Lieutenant Collins regarding?
At what time?
Let's start at the beginning.
Again, it's the same type of information that you asked about before, as far as reports or photographs or any material that they might have pertinent to the case.
So whatever the Milton police turned over to you, would you have kept notes of that somewhere?
Yes.
Would there have been emails back and forth between you and Milton about what transpired?
Yes.
Okay. Did you have any trouble getting information from the Milton Police Department?
No.
When you asked for things, did they return your email and give you what you were looking for?
Yes.
Were there any reports from the Milton Police Department that you say you didn't have before you turned the case over to ADA Hickman?
There was one report, yes.
And what was that report regarding?
Mr. Turner.
I'm sorry?
Mr. Turner.
And what about Mr. Turner?
There was a report in the materials that ADA Hickman turned over in 2025 that was, I believe, offered by Detective Sergeant Clifford Murphy pertaining to Mr. Turner that I had never seen before.
Okay, and do you know why that wasn't turned over by the Milton Police Department?
No.
Did you go down to the Milton Police Department and look through their file?
No.
At any point in time when you were representing the Commonwealth, in this case, did you go down to the Milton Police Department and look through their files?
No.
Is that something that you would normally do in a homicide case? Go to the police officer's office and ask for the file?
At what point in the case?
At any point.
Typically, that would be something that I would endeavor to do closer to trial.
Oh.
Closer to trial?
Yes.
So how could you make sure your obligation was satisfied if you're not meeting with the police until right before trial?
It's an ongoing duty and obligation that extends even beyond a trial.
Right, that's not my point. My point is, if you're not meeting with them and you're not going through their information, how do you know you've turned everything over to the defense?
Because I've requested it and I've been given assurances or information indicating that that is what they have.
Let me ask you the same question about the state police. Did you ever go through the state police file while you were handling the case, as opposed to making requests and even sitting down with the state police to make, face-to-face requests on an ongoing basis and all the follow-up contacts that you had? Did you ever actually request their whole file to go through it yourself?
That's
No.
the judge.
And
He needs to
can you
lose his
tell us,
job.
was there a policy within the Norfolk County District Attorney's Office of sitting down with police departments, whether it's state police or Milton Police, and reviewing their file prior to trial?
Not that I'm aware of, no.
Okay. So how far in advance of trial do you finally sit down and go through, let's take the Milton Police box?
It would depend, case to case, but it's something that I would probably do at least a few months ahead of trial.
A few months. And is that the first time that you put your hands on the actual box, or are you still dependent upon the Lieutenant Collins and other officers to give you what you're looking for?
Oh, that would be a time where I'm actually like, let me see the file and ensure that I have everything that you have.
Wow. You just
Is
trust
there a
me,
reason-
bro.
Is there any prohibition to that meeting that you have a couple of months prior to trial happening right after indictment?
No, and that would be my practice now. So you're asking about sort of my general practice at the time.
Oh, you changed your practice?
That would have been it at the time, but now I would do that much, much earlier in a case.
Oh, you learn from your
Okay.
mistakes?
And the state police the same way? Did you sit down with them at some point and look through their file, or you never looked through their file?
No, as his honor just asked, no, I didn't.
Never looked through the
So I guess my
MSP
question
file.
is,
Never.
how did it work? Did they only look through their file and send you what you're asking for? Or did it, at any point, did they send you here's everything that we have?
My request and my ask was for everything they had. So as far as me then double checking to ensure that I have everything they have, that would be something that would occur later on. And as I just indicated, my practice now would be to do that much earlier in a case.
Every case he's ever tried needs to be looked at very carefully.
So-
Every single one. Prisoners.
When you go,
Call your
in
lawyers.
this case, you knew we had picked a September 8th trial date, right?
I was aware, yes.
Okay. So you knew the case was ready for trial on September 8th. When were you planning on sitting down with the Milton Police and going through their file?
As the case was reassigned to ADA Hickman around the time that we selected the trial date, I don't know that I had a specific plan to do that. I did have a specific plan to meet with ADA Hickman to go through the file to ensure that she had everything that was there.
So by the time she had taken over in January of 2025, you had not made any plans to sit down with the Milton Police to go through their file, is that right?
She had taken over prior to that, but no, I hadn't.
Okay, and the same with the state police, is that right?
Correct.
Okay, so when you're updating ADA Hickman, when she takes over the case, do you tell her, I've never actually seen the files, it's on my list of things to do, but I never get down there, you should get down and take a look at the files?
Not that specific, but yes,
What did you tell her?
that, during the regular trial preparation or meeting with the officers as it gets closer to trial, I would do that, but I hadn't done that yet.
So, I'm still trying to understand.
We
Is
all
there
are.
like when the police give you something, do they just email it to you, or is there like a list to say, we gave ADA Lally these documents on this date?
As far as their list,
Yes,
I have no idea what they have.
okay. So you don't know, as you sit here today, if they have an index of all the things they say they gave to you,
I don't.
okay?
Good, put Proctor up.
And do you, on the opposite side, have
Proctor's
an
there.
index of the things you got from them?
It would be contained within those requests, yes.
All right, so at some point, do you print out all your requests and say, okay, let me just make sure I have everything here? I've been requesting something since, December of 2021. I want to make sure I have everything. Do you sit down and do that at some point to make sure everything you requested, you've received?
My general practice would be, yes, and that would be as I know we're getting closer to a trial date.
Attorney Scapiccio, it's
called
a
Brady.
little after 11, and we're going to be able to go until about 11:10.
What? He said 11:30
and then I have
before.
to break because we're going to have to do the motions to suppress on the two other matters. So we need to think about an appropriate time to break. Maybe now is a good time to break, and we need to talk about another date when we can come back and continue the hearing.
We want Proctor
Okay.
today.
Attorney Lally, you can step down. Thank you.
Get Proctor up. Rosemary, you got like 9 minutes.
for the record, I think the defendant's general motion for relevant discovery is docket number 8 in docket number 21 CR 320. That's what we were going to mark as Exhibit 1. It's signed by you, Ms. Scapiccio.
It was on behalf of Ms. Gardner.
I don't know. I didn't dig up a motion to join, but in any event, we're talking about what would be otherwise Exhibit 1. It's docket number 8 in the case. All right. Next dates. I would like to have the benefit of your comparison of the old and new, the earlier disclosed and the later disclosed, and how the various items are different.
So,
Might I ask also that the court order if they're materially prejudicial to the defendant as we explore
No.
discoveries?
Yeah, I'm not sure where your microphone is, but if you can, your mic, can you speak right into the mic?
May I also ask the court to order what is materially prejudiced that have
Right.
these materials from
Right.
us?
It would be helpful to me if you're proceeding on a prejudice argument to know what it is that you contend is prejudicially late disclosed, okay? And,
might take a little longer, Judge, because last Thursday, we got some additional discovery from the Commonwealth.
well, let's start in tranches, okay? We can deal with April, and then we can deal with May.
Okay.
And if we have to deal with it in parts, we can deal with it in parts.
Sure, Your Honor.
But I don't know how much time it's going to take for the parties to get together on this, and I don't know how far out we should look at a date.
And as far as the time frame for the material, how about when counsel filed the motion? Up until that point, I'm not going to. Mr. McGee is suggesting that which of the documents produced as of the time you filed the motion for sanctions or to dismiss,
Okay.
do you now view as prejudicial? That is to say, and frankly, how you were prejudiced. Okay, this is a witness who's deceased, or we have no way of following up on this, or whatever it is. Okay.
That's only part of the other, I don't want to not meet before that.
Will be.
I mean.
I would like you to do a week, spend a week to try to get back and forth together on these.
Sure.
There's a long list, but it's not voluminous. You can deal with it. You've been through these documents. Each side has been through the documents.
Sure.
So hopefully you can come up with a list. And I'm happy to give you a date when we can continue this hearing.
Sure, Your Honor. How far out do you think we need to go?
Well, it depends on when you can get that list together. I don't know how long it's going to take for you folks to get together, but we could do later this week for continuation of the evidence. We could do the following week, I believe, on the 29th to 30th in the morning. I'm not 100% sure.
Could I bring the other parties in? I think.
Sure.
Another ADA is drafting.
Sure.
Parties.
Great. We got to get their schedules
And
together.
I know
We're not
we
going to
have
get to see
counsel here
Proctor
for
today, but we got to see Lally.
Parties, so.
If somebody has the transcripts of all the various hearings,
I do, Judge. I'm happy to share them with everybody.
yeah, share them with everybody and let's.
Got this to be literally late last night.
All right, but my point is, in the next hearing, stand up and say, Exhibit A is all the transcripts of the various hearings on discovery. That's Exhibit 1, okay. And Exhibit 2 is our reconciliation between the documents, and this is the way in which they're different or new, okay. And Exhibit 3 is whatever else you want. Here's our discovery report, and here's my discovery motion, and here's the motion. You don't need a witness for that. These are all part of the record, and so there's going to be no contest as to any of that. That's just putting in the record. And then if you have specific questions for somebody, ask it. But, so I think this can be done in a much more streamlined way. And hopefully
Except
we can do
no
it that way.
documents or records of any of it.
How much more, what other witnesses do you anticipate?
I anticipate Trooper Proctor, who didn't join us today.
Oh, he didn't?
And I anticipate
Oh, but he's there.
ADA
Hickman.
Those are the only three that I've subpoenaed, but based on the testimony, I think we're probably going to need Lieutenant Collins as well, Judge, and maybe Trooper Tully.
Tully is there today. We love you, Rosemary. Oh, yes, we do.
All right, how many witnesses do you think you're going to need?
Will be true.
Trooper Tully here, Deputy Chief Collins, and Officer Benda regarding the Milton issues. And there's a motion to quash, and I know Your Honor's up against somewhat of a time with respect to ADA Hickman being the predecessor counsel and now counsel of record on the case, that she can answer any questions the court has that are remaining from right where she stands.
All right.
And opposing the production of.
All right. So we have 4, maybe 5 witnesses left. So we need a day when we can do this in an efficient way. Jim, how does our calendar look?
Well, 7/29, which is a Tuesday, is particularly good.
Particularly good.
Well,
there was a reason for that. I'm trying to remember what that reason was.
Tuesday.
We have a noon lobby conference.
There's a lobby
I
conference.
have a federal case on, so.
29th is not going to work for you, okay?
How about the 30th in the morning?
We have anything on that morning?
We do not.
No?
Can we potentially push this to the first week of August?
The 30th is a problem for you?
It is. I can have August 5th or 6th.
6th is out. 5th is a possibility, but I don't know what we have that morning.
Okay. How about
According to me, the 5th
7th?
isn't good.
That's blocked up. Let's just pull up the list for the 5th. I know I am not away that day.
Now we get a good look at Jim's forehead today.
The lobby.
All right, so it looks like we could do August 5th.
Just could, I know that,
Can you do that?
I can.
All right.
Does it work for
Witness issues, August 5th? That's okay? All right.
so Judge could, I know that, Trooper Proctor's attorney is here. We did serve him in hand today. Could he communicate the new date to him so we don't have to reserve him? I don't want to go back to his home.
Morning, Your Honor. Dan Moynihan on behalf of Michael Proctor.
I don't want to go back
He
to his
can be
home.
available August 5th.
Okay, good. So, 9 o'clock?
Sure.
I would like to get the agreed to exhibits, including the transcripts of any prior hearings, any prior filings that you want to draw to my attention, the reconciliation of exhibits, et cetera, in advance. So I am away the 31st and 1st. So if I have them here by first thing on the morning of the 4th, I'll read them all before the 5th, okay? So I'm not trying to create artificial deadlines for you, but I think everything will go faster if I've had a chance to take a look at the agreed to exhibits, okay?
Absolutely, Your Honor.
All right.
Thank you, Your Honor.
Thank you, Your Honor.
9 a.m.
We'll take a 15-minute break and reconvene 11:30 on the motions to suppress.
Thank you, Your Honor. Thank you. All right.
Wow. Wow. We just watched.
Do we have Zoom going? Sorry.
Here's hot mics, hang on.
Yeah, thank you.
Hey, Jim. What up, Jim?
Okay.
All right, I think that we are not gonna.
I'll get back there to speak to David tomorrow.
And we're out of the Zoom. Wow. We have just gotten an inside look at the way that the Norfolk County District Attorney's Office has been operating for decades, in my opinion. Adam Lally said that he's been there for what? When did he first start working there? I don't know. My notes are a mess. At least 10 years, right? 20 years. 20 years he's been working there. We learned he went to USC and then he went to Suffolk Law. He's been working there for 20 years. Apparently, they have no procedures and he doesn't take a lot of notes. and he has a lot of selective amnesia. And, Proctor just didn't give him stuff. It is 4 years since the date of this murder that this defendant has been awaiting his trial. And Proctor just realized that he only turned over or exchanged with the defense 1.5 search warrants. This is the Myles King case. That was wild. Proctor was in the building. He didn't get a chance to be called because the judge had other cases to hear today. So they're going to come back on August 5th. And I just was blown away by Lally's testimony. He had an ethics attorney with him, and with good reason. Because that's the way they do things there. This is going to blow the doors off Karen Reed's civil case that will be sure to come soon. Proctor was there today, actually, I believe. He was. They said he's here, but we're not going to hear from him. Tully was also there. Tully's waiting to be called. So Proctor can't plead the fifth. No, he sure can't. He sure can't. Hang on a second. It may be on a question-by-question basis, but he's got an attorney with him. Proctor did today, and she said, I don't want to have to go back to his house to subpoena him again. So I wonder what happened the first time she subpoenaed him. Thank you, JoJo. I just finished watching your live stream with Turtle Boy. I love it. About Rotten Mango, her covering of cases really puts attention, and it's frankly needed. Too many nefarious things happening. Yeah, Rotten Mango has about 5.5 million subs, and she started covering Karen Reed. If you haven't watched her first video on it, it's about 2.5 hours long. She has a great board of all the players, and it already has last night, I think it had 1.6 million views already. So a lot more eyes are turning to the Karen Reed case, and it's pretty cool. Aman says that the defense lawyer is no joke. She got off a Patriots player that tried to carry illegal magazine clips and guns in his carry-on bag. She got him off. Yeah, she's no joke. Aiden Carney said on my show last night that she was his first phone call. And she was too busy to take his case. And he loves Bradel. So no shade to Bradel and Betterow, of course, because we love them both. Thank you very much. Mary Lynch said, hey, Mel, great show with Aiden. Glad I connected you two. You did. You were the reason we got connected all the way back in October 2023. And then Aiden was arrested, and then he went to jail, and the rest is history. And last night was the first time we did, a sit-down conversation stream, and it was really fun for 3 hours. For the love of the traveling troopers, as all cases Proctor was involved in should be looked at. Oh, they are. Oh, they are. There's a lot of them out there that have him that are upcoming for trial. And that's the reason that this hearing in particular is so important, because Judge Krupp made Adam Lally take the stand. Wow. Wendy, what happens to all the other evidence from this trial since it's technically a cold case? I'm not sure what you're talking about. The hearing that we were watching is the Myles King case. That trial has not happened yet. It's 4 years old. Myles King was in jail for 3.5 years until a couple of months ago, they finally got him out on bail. There's no speedy trial statute apparently in Massachusetts. And I don't know if you're talking about Karen Reed, but if you're talking about Karen Reed, it's not a cold case. The trial's over. So I just don't know what trial you're talking about, because Myles King has not had a trial yet. Jeannie, Proctor, if photos of Anna, very likely and sickening, like Puconic sickening. Your focus on the mouth of hell in Massachusetts will bring change. Thank you, Mel. Thank you. Thanks, Jeannie. Jimmy from Lynn says, I'm the voice of attorney Scapiccio. She is a post-conviction animal for an attorney. Melanie, Google her. Oh, I know who she is. I know. I'm familiar. Thanks, Jimmy. Donnie, Mr. Lally, do you think you're having memory problems? Is it because you ate a ham sandwich today? I asked because we don't know what happened over here. Nick Starro is here from Sweden and says, Lally, I request reports. Which damn reports? And if that is what he normally does, why were there hardly any in Karen's trial? Is there discovery out there on the Karen Reed trial that the defense never got? I have questions. And my answer is probably yes. And also, this is exactly the evidentiary hearing that Judge Cannoni should have had during the motion to dismiss for extraordinary governmental misconduct. But instead, she just drafted her, 24-page decision without calling one witness, like perhaps Fanning, and him having to be questioned about whether he had any contact with the jury. and Lally and McLaughlin about where that video was, where the Sallyport video was, why they didn't turn it over when they got it. This is exactly what Rosemary Scapiccio is doing. This is exactly what Judge Krupp is allowing her to do. And this is what Judge Cannoni should have done, but didn't do. Dude Greg says Lally just needs to rat Proctor out and save himself. I think that's what he was doing. But he's not done on the stand. He's going to come back on, what did we say? August 5th? I think it's August 5th. And they're all going to have to testify. It's going to be great. He's telling them everything, just Irish. The troopers run the office, not the prosecutor, says Victor Mann. That's exactly what I was thinking when I heard him say, oh, well, when I get a discovery notice from the defense, I just send it to Proctor. I send it to Tully and expect them to give me everything in the demand. I'm sorry, what? That is bizarre. I don't know anywhere else why that happened, where that happens, but this is also the only place I've ever heard of where specific troopers are assigned to a district attorney's office. It's crazy. Donnie says, Karen, you deserve this. Justin, Karen was in the chat before. I don't know if she's still here. Sharon is Rage Crochet. We have a Rage Crochet club here. That's how outraged people are. Snark Tank says, amazing. Karen Reed's revenge tour fodder happening live. Isn't that wild? Joe Pa said, can Lally text a victim advocate to demand something be done about Krupp? I don't understand this question. Lally's an attorney. He's also a witness here, but he's not getting any victim witness advocate. He has an attorney representing him, so I don't really understand the question. Josie says, this is justice, and it just started. Wow. Thanks for your 20. We're here for it. We're here for every minute of this. This is like revenge is sweet. Thank God Karen Reed was acquitted, but this is so much more fodder for her civil case that I am sure will come eventually against the county, the state, all of them. He's telling us everything. Denise says, this is the first day of real vindication for Karen Reed and Turtle Boy. Coach says, I just got on. I followed the whole Karen Reed case. So can you please explain to me what is going on and talk to me like I am 5, please? Okay. So all of the other defense attorneys in the state in which Proctor was the lead investigator have been notified about Proctor's problems. It's been going on for a while. Proctor's problems. He's now on the Brady list. He was fired because of his bias in the Karen Reed investigation, the Karen Reed case. And so he goes on a Brady list. And so all the defense attorneys that have cases currently pending in which Proctor is a lead investigator or had any hand in the investigation, all of those defense attorneys are notified about Proctor. They're all entitled to get his messages and his iCloud messages. A separate issue is that those messages were supposed to be destroyed pursuant to a federal order 30 days after the end of the Karen Reed trial, which would have been July 18th. And a bunch of attorneys went to court last week and said, we were just notified yesterday that these are going to be destroyed tomorrow, and you can't destroy them because we're entitled to them. We're entitled to see if Proctor had any bias with regard to our defendants as well. And so they're holding off for a week from destroying it because, the Norfolk District Attorney's Office would have just destroyed them because, it's going to embarrass them maybe or prevent a couple of convictions maybe in their cases. So this is an evidentiary hearing in a case called Myles King, and it's a motion to dismiss. And so Judge Krupp is allowing Rosemary Scapiccio, the defense attorney for Myles King, to call witnesses about why stuff wasn't turned over. Evidence that could be evidence, any kind of evidence. They have requirements under Brady and under other Massachusetts law to turn over, to automatically disclose evidence. And it turns out that there's search warrants that they still haven't turned over 4 years later. And we heard Adam Lally testify about all the things he didn't know or do or remember, and his lists and his notes, and who he spoke to and who he doesn't remember speaking to, and what his policy and procedure was. And he doesn't remember a whole bunch of stuff. And this is shining a light on the long-term corruption and incompetence of the Norfolk County DA's office, perhaps, in my opinion, because he's been there for 20 years, Adam Lally. How many other cases did this happen in? How many other cases did he just, hit the snooze button and forget to turn over things like search warrants, police reports? He's just relying on the troopers like Proctor and Tully to turn over what they think is required under the discovery orders that he forwards to them. And it's just like, trust me, bro. He's just trusting what they send him. He's an attorney. He is an attorney. He has an affirmative obligation to turn this stuff over. And he just sends it to them. Who's really running the county? Who's running the DA's office? The attorney that was accompanying Adam Lally today, that was representing him, is attorney Patrick Hanley. He was appointed to the State Ethics Commission on June 16th of 2025. Lally, be scared. Lally, be scared. How many Brady violations do you think Lally could be responsible for because he put his trust in the Massachusetts State Police and the troopers assigned to the Norfolk DA's office? And he was appointed by Maura Healey to the State Ethics Commission. Commissioner Hanley succeeds former commission member and vice chair Josefina Martinez. Could be a problem. Lally could be in big trouble. In my opinion, maybe, perhaps. Liz says, Mel, bring better on. I love you two together. Liz, thank you so much for the suggestion. That's just not the way it works. It's just not the way it works. Mark Betterow works. It's not like I can just call somebody up and be like, hey, come on right now. Sometimes it works out. Sometimes it doesn't. Thanks for your suggestion, though. Thank you. You would love a Melanie and Betterow follow-up? If we can get it together, we will. I can't wait to hear what he has to say about it, although Lally's not involved in Aidan Carney's case. Judge Krupp did hear a couple of things on Aidan's case. And he's tweeting. Let's see what he's got to say. We can always look to his tweets. He might be in court today. Hang on. We can get his thoughts by looking at his Twitter. Thanks, Suze. Oh, I love it when he validates me. 35 minutes ago, Adam Lally, if you choose to believe him, is the poster child for willful blindness, conscious avoidance, and absolute indifference. His testimony today is an embarrassment to the wonderful profession of prosecutor. The Norfolk DA problem is far greater than Karen Reed. It is cultural. Indifference, coziness between the MSP and the DA, and incompetence. Just a complete shit show. That was tweeted by Mark Betterow about 35 minutes ago. That's where he stands on it. So I was not overreacting. I absolutely agree with him. And this has blown the doors wide open. Duncan, Idaho said, a guy like Lally doesn't demand anything from a guy like Proctor. Proctor probably figured he could safely ignore Lally's requests with impunity. I agree. ShamWow says she got no quit. I am loving this magical Monday. It's a magical Monday, isn't it? Snark Tank. I saw Yuri Proctor at the water cooler daily, and there was bully fear to deal with the corruption. It's our version of workplace politics. Ringa says, is this first Proctor fallout case to go to court? This is the first time that anybody has ever made Lally take the stand, or any of these witnesses take the stand in an evidentiary hearing regarding their failures to turn over evidence. Harry Turk's case, Dr. Turk's case, went to trial. Proctor was, I think, the lead investigator on Turk as well, but they did not call him, and there was no testimony really about him. And so, no, it was not an issue there. So it's not the first case to go to court, because Turk's case was tried, but also Brian Walsh's case is pending. And on, I think, Thursday, we have a hearing on that motion to dismiss. That's also going to be fired because Proctor was involved in that too. And because of Proctor's search warrants that he lied in, it's another big issue in the Brian Walsh case. If you've been following that, I have a playlist on it. go to that case as well. So it is the first time I've seen Lally get on the stand, but this is not going to be the last, I have a feeling. Retro says, I don't know this case. Is there a particular reason these warrants being withheld is so crucial other than a general Rule 14 violation? I don't know what the warrants contain because I have not done a deep dive into the documents on this case. So the answer is I don't know. I'm going to try and find out and get the documents, but they have an obligation to turn over discovery. And I think it is just a small piece of the systemic problem. And who knows what else they didn't turn over or forgot to turn over or failed to turn over or turned over late, because Rosemary Scapiccio is just getting started. ProHawk VJ, did Lally commit perjury? He responded, never having issues with discovery on other cases. What about the Sallyport video? I have to go back and watch that testimony more carefully, to be honest, because I was a little distracted by the chat and trying to get that stream up. So I have to go back and listen to exactly what he said and what the question was. But yeah, he has had issues before. And I think the order of things may have been that the Karen Reed case was after this one. So I have to go back and listen to the question, but maybe. Can Rosemary call Proctor in this case? Yes, she intends to. Mildred, this totally blows the Commonwealth's representation that the problems in the Reed case were isolated. Oh, doesn't it though? Doesn't it? Prisoners, if you're watching. Defense attorneys, if you're watching. How many other cases has Lally prosecuted? Hell a lot. 20 years worth. Have I ever seen anything like this, RJ and Elsie? No, I never have. This is the highest level of effery, let's just say. Can't make this up, says everything in the bottomless pit, aka Proctor's bottom drawer. Right. Like Judge Krupp didn't allow an evidentiary hearing in that motion to dismiss, but in her 24-page decision, or however long it was, she did say it's all Proctor's fault. Proctor held on to all that Sallyport video and he didn't turn it over. Okay, where's the fact pattern for that? How do we know that? Proctor didn't testify. Why didn't he get on the stand? So he could be asked about it. Snark Tank says violations of the ADA takes on new meaning today. Oh, yes, it does. Lola, I imagine this is what an evidentiary hearing in Karen Reed would have sounded like if Bev had actually allowed one. That's right. Fairy Raven said, I didn't know I needed to witness this today, so thank you, Millie. Oh, you're welcome. Reed Little and Scapiccio, says Lisa Marie Mott. Best Monday morning ever. Warriors. Topher Brains, why not make all files in the possession of state available to the defense, period, as in defense can walk into the DA's office and open and look at whatever they want? No, because there's privilege stuff in there. There's work product in there. So they can't just have open access to another attorney's file. It's not how it works. But there are requirements and Brady obligations and discovery that has to be turned over automatically. And trust me when I tell you they know their obligations, because all you need to do is go back to the furious manic letters between Michael Morrissey and Josh Levy and Lynn Beeland and Josh Levy. And Michael Morrissey's like, I fully know my Brady obligations. I know I have to turn all of this stuff over to the defense. I need to know what you're investigating, FBI, and I need to know what you have and who your witnesses are, because I need to turn it over to the defense in the Karen Reed case. And that goes back to what, 2023, starting in April. Snark Tank says the judge is giving Schitt's Creek's dad vibes. Lori's order says, honestly, this is so gratifying. A delicious affirmation of all the mass corruption. It's sick. And the girl with no quit is bringing down the house. Free Karen Reed, or Karen Reed is freed. Can Proctor plead the fifth? It depends on what he's asked. If he, the answer is, I don't think there's a blanket fifth privilege in Massachusetts, and he's already testified in other cases. So the answer is, I think it's going to be on a question by question basis. He has counsel. I think they tried to quash the subpoena. They're coming back at 11:30, but to talk about the judge has other matters, other cases. This case has been put over until August 5th. So no, they're coming back at 11:30, but not for this case, for other cases. They're coming back on this case, August 5th at 9 a.m. Thanks, Broken Baker, and his viewers are here. Hey guys, wasn't that fun? Jojo says they really need to check the water in Norfolk because a lot of people are having memory problems. Aren't they, though? Nina, do we know why Lally had been removed from the King and Gardner cases? By the way, loved your conversation with Turtle. Thank you. No, I don't know that he's been asked that yet. Or maybe he was asked and the judge sustained the objection, like it wasn't relevant. I'm not sure, but we know when, right? Didn't we learn when? My notes are a mess. I'm going to have to look for that, to look. But he said that June of 2025 was the first time that he learned, Adam Lally learned, that the search warrants weren't turned over. Because, of course it is. Shamwow says, can't wait for a full Proctor examination. Well done. G says, read venge. More of a less thing. I just want to know when I don't recall became the acceptable response to, did you do your job? It's the go-to answer. And you can see now how Adam Lally preps his witnesses, right? I don't know. I don't recall. I don't know. I don't recall. I don't know. If you have it there, I'll look at it. JMX says, thanks for covering baby shark hair for Shark Week. Is it Shark Week? Greg says, now we know why the Commonwealth bent over backwards to get a Karen Reed conviction. Yep. And guess what? It didn't work. And now the dominoes are starting to fall. Right? Hold please for 1 second. One moment, please. Who is going to be streaming the Stephen Stern's plea hearing? Is Law and Crime doing it? Because we should come back at 1:30 and do that, yeah? I'm like looking for my subscriptions and I'm seeing my face on the Seeking Justice with Tommy and Boston Mike. Hey guys over there. I guess they're restreaming me. So hello to everyone who's watching from over there. Stephanie says, brand new member here, lawyer from Montreal. Thank you so much for covering this today. Oh, it is my pleasure. I didn't know it was going to be as exciting as it was. And sometimes it's exciting and sometimes it's not. An hour behind me catching up. Layover in Denver. Thank you, Banana. Did Boston add Dever to the Brady list as requested? Don't know. Don't know. That is something that the commissioner is supposed to do and or the DA's office. And I don't know exactly what their procedure is. And I don't know that they're going to respond to Alan Jackson about that either. But I would imagine that defense attorneys would start to be notified about any cases that Kelly Dever was supposed to be a witness in. And that's how we would find out about it. It's a motion to suppress in a different case, right? Right, Rainy Day? It's not their case. They're coming, aren't they coming back on August 5th? Here's Turtle Boy. I'm behind, but I've written about Attorney Hanley before. He has represented the state police union, but he was very friendly with me when I met him a couple of months ago in court. It's a motion to suppress in this case. All right, hang on a second. Hold on, please. He said they were coming back. He had 2 other cases on. That's what I heard the judge say, and I looked at the calendar too. So before I go through this, can somebody just confirm it with me? Yeah, please don't direct people to other channels. Thank you, though. Also, I can't rewind on the Zoom, so just we'll just hang here for a minute and see if it's the same case. Said on this case? All right, I'll turn it on. I mean, I have it up. We'll see if they, but I don't think it's on this case because I have the court calendar. So unless somebody really knows for sure. Thank you, Josie, for your 50. This is an opportunity to sanction him, even disbar him due to the failure to abide to laws and even policies and procedures any district attorney should abide by. Imagine Dedham Superior Court claiming ignorance should be enough to disqualify any DA. Yep, that is right. Well, it says waiting for them to start. This is the same courtroom that we were in before, right? Courtroom 25. Thank you for your 50, Josie. Very generous. Thank you for the love of the traveling trooper for thanking me. Larry, how prevalent is this practice throughout the Commonwealth? It's scary to think that this is incompetency is that prevalent. Yes, well, Lally's been had that position for 20 years. 20 years. Five top stories. Stearns reportedly prepared to plead to murder. Yes, I know. I've got it. Please don't write those words in the thing. I was recently demonetized on 3 separate videos that I've appealed 3 times and I cannot get monetization on them. One is the Aaron Spencer case that I covered, which is like a couple of hours. The other one is a post Karen Reed trial thing where, I don't know, there must have been a picture of the arm in there. Like, it's insane. We are outraged. So have they started this motion to suppress? Motion to quash for this case at 11:30. All right, again. Thank you. Oh, you got demonetized on Aaron Spencer too? I'm so glad we're both covering this case. I'm outraged by this case, Bob. I'm outraged by it. And they don't want anybody to know about it. There's so much corruption in that case. You thought Indiana was bad? You know, Michael Fossler used to be the chief of police in Hamlet, Indiana, and you cannot find any reference to that on the internet at all. They have scrubbed it from the internet. You can't find it. I'm outraged. So I guess they cut the feed. I don't know. Motion to quash for this case at 11:30. I don't know. Did you notice more of the McAlbert group text shown on Rotten Mango video than we heard at trial? Dead comment. No, did not. I didn't. Was it trial 1 and trial 2 that she covered? AJ mentioned severe consequences if Cox isn't putting Dever on the Brady list. What did he mean by that? I think you'd have to ask him. Thanks, Edel, for your super sticker. Thanks, Luann, for your 10. Appreciate you. So I don't know how anybody's covering this motion to suppress or how anybody else is seeing it, because I don't see it. And somebody said on Young Jerks that they cut the feed as well. Is that true? Ooh. Well, this is interesting. We have a new motion in the Karen Reed case. Hold on. Want to see a new motion in the Karen Reed case? Hang tight. Hold, please. It's a motion to amend her travel restrictions. Thank you, Marie. Marie said, I need a love laugh button for the comments when Lally was testifying. Jesus, that was a blast. Thank you, Sherry. I am unable to send supers help. Supers were turned off on the Turtle Boy stream. So if that's where you're trying to do it, they were turned off so that people would donate to his defense fund. But Sherry, for your Cash App, thank you. You have to send me your channel, your YouTube channel link to my email, which is below this video. It's the only one I use for YouTube. fanbase@mlittlelaw.com. Send me your channel link, not your username, not your name, and I'll have the team look into it. Thank you, Nikki, for your Venmo. Says appreciate you. Thank you. And Beth says you rock. Thank you, Beth. No, you do. You do. Anita says thanks for streaming the hearing. Thank you. You're welcome. Jonas says Lally on the stand. Any thoughts on Eugenia now? Aiden felt she full on lied during one of his hearings. By the way, I loved your interview with Turtle Boy. It was absolutely original. Thank you. Thank you. I don't have any thoughts on Eugenia because we watched that trial and I didn't find her to be as bad as some people thought in the beginning. And again, if you're emailing me because you think you're blocked on my channel, you need to email me the link to your YouTube channel. YouTube has been acting very wonky lately, and it has been blocking people. It has been unsubscribing people. Any of the other creators in the chat can back me up on that. It's been happening a lot, but I can't do anything unless I have your actual channel link. So just sending me a complaining email about it is not going to do anything to solve your problem. So thank you. All right, let's take a look at the new Karen Reed motion. So yeah, the Zoom is not happening. So I don't know what you guys are talking about, but it's not there. So I don't know if anybody was actually in there or if they cut it. I have no idea. One second while I pull this stuff up. And this was filed on the 15th of July, and today's what, the 21st? Oh, I don't know why we're just getting it now, but it is what it is. Here is the defendant Karen Reed's motion to amend the terms and conditions of her probation to remove travel restrictions. A lot of people were asking about this. Is she allowed to leave the state under the conditions of her probation? And I guess we're going to find that out. And here's defendant Karen Reed's motion to amend the terms and conditions of her probation to remove travel restrictions. Now comes the defendant, Karen Reed. Ms. Reed, and respectfully moves this honorable court for an order amending the terms and conditions of her probation to remove the travel restrictions associated with her probation. Hold on, I'm getting parched. On June 19th of 2025, Ms. Reed was convicted of a single misdemeanor count of operating under the influence, OUI, and was sentenced to 1 year of probation and participation in an alcohol education program in Norfolk Superior Court. On June 23rd, 2025, her probation was transferred to Bristol Superior Court. Ms. Reed has been in complete compliance with all terms and conditions of her probation, including all reporting requirements, and will continue to do so regardless of any potential travel in the future. As a term and condition of her probation, Ms. Reed is restricted from traveling outside the jurisdiction, out of state, without first obtaining advance permission from the probation department, and in any case for a maximum of 14 days. So it looks like there's it was not Judge Cannoni who signed off on this, by the way. This was, there's a little signature here on the side, 7/15/25, allowed. And it looks like the judge's name is Yesayan, Yesssayan. And it's because this was made in Bristol County. Hang on, I gotta take this off and then put up number 2. Ms. Reed respectfully requests that these travel restrictions be lifted such that she can travel outside the jurisdiction out of state without advance permission from the probation department, and that her time of travel outside the jurisdiction be unlimited. Of course, irrespective of any travel, Ms. Reed will continue to honor, abide by, and comply with all reporting requirements and other terms and conditions imposed by this honorable court and the probation department. Counsel and Ms. Reed have spoken directly with Chief Probation Officer for the Bristol County Superior Court Probation Department, Robert Blackburn, and he has indicated that he has no objection to modifications of Ms. Reed's probation terms and conditions as requested herein. Officer Blackburn indicated that Ms. Reed has been and remains in complete compliance with all current terms and conditions of her probation. For the above reasons, Ms. Reed respectfully requests that this honorable court modify the terms and conditions of her probation to remove her travel restrictions as described herein. XOXO. Alan Jackson. Wow. And it was allowed. So she's allowed to freely move about the cabin. Praise be. That's awesome. Hold on. Hold, please. Now she's truly free. I know. That is crazy. Hold on. Give Lally a plea deal and make him snitch some more, says hypochondriac. Tinfoil Hat Society says the worst part of Proctor's text wasn't his vulgar words. It was the fact that Karen Reed was guilty a few hours after the incident. Yeah. Agreed. Oh, well, Mark, if you want to come on right now and just give your thoughts, that'd be great, because we're going to wrap soon before we move over to Stephen Stern's plea hearing. So you can come on and give us some quick thoughts if you like. You ask for Bettero, you get him. He's available. See what he's got to say. He just got back. It's fantastic. Kraken Studios, FYI, also YouTube is hot blocking yet timed out, folks. I don't know what that means. To help toward the streams or to demonetize. Thank you, Mrs. Bouquet. I appreciate you. All right, here we go. Here's Mark Bettero. You asked for it. You got it.
How are you?
I'm good. How are you? I'm better than Lally's day is going, I imagine.
I saw most of it, not all of it. I saw it on yours. It probably started maybe 10 or 15 minutes, but I saw the last 25 to 30 minutes. I even threw a few gratuitous comments in your chat. Wow, that how validating for so many people for so many different reasons, and how upsetting it must be, frustrating for Team Reed to have been denied the absolute right that they were entitled to come after all of these clowns and expose the cultural failures of that place, the inability of them to know their obligations. And, watching Lally, it's as if he doesn't understand that the Brady and discovery obligation, although it applies to information in their possession, custody, or control, including the police, the ethical obligation is his, and essentially his alone. And the absolute indifference, willful blindness, conscious avoidance, time to make the donuts attitude that it's good to see is still alive and well a year after that was first coined, is just unbelievable to watch. And he's been doing this 15 or 20 years and has no concept at all what a prosecutor's obligations are. And of course, I can speak from experience on what they are, having done it and driven other prosecutors crazy for much longer than that in the same issue. And his answers are nonsensical. They defy logic. His so-called practice is really non-practice. I mean, his failure to log what he discloses in important cases like this, his failure to bait stamp, his failure to state on the record and provide a list of everything he turned over. That's what real prosecutors do, and apparently not in Norfolk County. And if he had done that, there'd be no dispute. I mean, he would say, look, you have these warrant affidavits, they're bait stamps number X through Z, and were disclosed on this date, and here's a cover letter, nothing to see here. And he has nothing to add other than, I don't know, I asked for it, and then I just seemingly forgot. And he never demanded, he never poked and prodded Proctor or his superiors. And I think that all comes back to the just incestuous coziness that exists between these people. They're too friendly, they're too connected, they're too locker room, they're too drinking buddies to say, you know what, where the hell's the material? It's a murder case. There are 6 search warrants. It's automatic discovery. I don't know if any of it is prejudicial or not. I don't know, exculpatory, whatever, but the defense is entitled to it. And where is it? And it's not good enough just to say, I'll get it to you, I'll get it to you. And at one point he said he met with Proctor and he was asked, did you get it? And he said no. And if my memory is correct, the only question I would have liked to have heard from her was, why were you there, sir, other than to collect the material? And when he said, I'll get it to you, why don't you say, okay, I'll tell you what, I'll sit here and pull out my laptop and work, go get it. It ought to take 5 minutes. It ought to be on a database. It ought to be electronic. Send it to me literally right now. And they have no answers for any of this. And it's clearly the culture of the place. And it shows the negligence of the way they operate and the negligent supervision. And those are important words for a potential claim, under 1983. It's not easy to sue prosecutors or government agencies that are non-police, when you're talking about a 1983 claim. And this almost certainly is something that may bring in the Norfolk DA's office under a failure to supervise type of negligence theory, that these are the very same actors right before the Karen Reed case who were doing the same type of thing. Unbelievable.
Exactly. It goes to pattern of conduct. I mean, the fact that he made it seem like Proctor's running the show over there. The fact that he said, I just give the discovery demands to the Massachusetts State Police and trust that they're going to respond to them and give me everything that's asked for.
And I'm assuming there's a lot more cross to go. And so you have to put an asterisk next to, I wonder why this wasn't asked. It's probably coming. But and if I missed it, I apologize because I missed the beginning. Probably not, based on the tenor of what she was doing. But the real question for him is,
I mean, I always ask these people in these types of hearings, what is your understanding of Brady? Seriously. And I don't know if this judge would allow it or not. Probably not, given his proclivity to just like, let's move this along. But, whose obligation is it? What is your understanding? Who's responsible for disclosing it? And, you must recognize that saying I count on Proctor only works unless and until there isn't a problem, because the buck stops with you. I mean, and his attitude of indifference.
Yeah.
This is the same thing that happened in Karen's case with the video. If you believe him, their answer in that motion to response was, well, Proctor kept it in his pocket for 2 years, the video, the famous Sallyport video. And of course, the question everybody wanted to know was, how could Lally not know that? Did he not ask? How do you not know these things? And the answer apparently is, I just said, make sure I get everything. And I assume he's telling the truth. I mean,
trust me, bro.
The reality is this: Adam Lally should be terminated. He really should. He's not. If this is how you testify about your practice 15 to 20 years into the game on serious homicide cases, some guy who may very well be guilty as hell, I have no idea, don't really care, frankly, is rotting in jail. This is a state that has no speedy trial statute, which is another disgrace. So there's no incentive. I mean, murder, I know in New York is exempt from speedy trial, but still, there has to be consequences. Certainly, there's a bail attachment to being released, which finally happened here. But for him to just say in a homicide case, I just wait on them and I don't know. And I think it's something like you said, 4.5 affidavits in search warrants in a murder case that don't get disclosed until I think what he just said, or he didn't become there until last month.
Yep. They turned over 1.5 out of 6 search warrants that Proctor drafted.
He should be terminated. He's not competent and capable. They won't do it because it will look bad for what's probably coming down the pipe with 1983 actions and all that. But he clearly has no understanding and frankly doesn't seem to care. I mean, his indifference to this is some of the most shocking part of it. He just looks the whole time like he's thinking, what's for lunch and what's the problem here? You got it. We haven't gone to trial yet. And what did he say? Well, I make sure all discovery is turned over right before trial when I go meet with the state police. Well, how about what the statute says and what Brady says? And you go by that timeline rather than your own convoluted, twisted timeline of when you think you should. This is also so bad for Morrissey politically, for everyone to see that, Karen Reed is not a one-off. This place, train wreck. These people running the most serious cases, and both at the prosecutor level and at the lead investigator level, which I'm sure we all agree Proctor was the lead investigator in this, not Karen's case, that they are completely incapable of keeping track and disclosing of what they did previously. And it's all, trust me, bro, like you said. And they all need to go, starting with obviously the elected official. But this is insane that a guy could sit in jail for 3.5 years and has not been provided with search warrants that presumably led to some of the evidence that could incarcerate him for the rest of his life, which were drafted in 2021. June of 2025, the prosecutor had no idea that I didn't disclose search warrants, which the prior transcripts show he was aware of. He talked about many other things. Another issue in Massachusetts, which is crazy. Why are the cops doing the search warrants on their own? I've never understood this. In Manhattan and certainly other New York City areas, the prosecutors write the warrants. They meet with the detectives. The detective is certainly the one who signs the affidavit, but it's literally drafted by the prosecutor and also signed by the prosecutor. The idea that they outsource this kind of stuff to the state police and then say, just get it to me whenever you can, is insanity.
But now we know that he keeps all kinds of notes. He keeps all kinds of notes. I mean, this is the hearing that should have happened during Karen Reed's motion to dismiss for egregious governmental misconduct. The judge didn't want to have one, just issued her decision based on her own feelings. And this is what we would have seen.
Yeah, and there would have been a really strong argument that this was intentional. I mean, look, this will all come out in the depositions, unfortunately for Lally, Proctor, and the rest of them, in a federal civil rights claim, which I assume is coming down the pipeline at some point. I would very much think so. But to hear them just have no clue or concept of who's responsible, what it means, or even any sincerity in being concerned about this is a huge mess up, but it happens all the time, apparently. I mean, it happened in Karen's case. And, the idea that the judge wouldn't give them a hearing because, well, I find that it wasn't disclosed, but no harm, no foul. And she never even gave them the chance.
No prejudice.
To poke and probe, not only about prejudice, but whether it was intentional.
Meaning the trial.
Meaning Proctor. Forget Lally in it. But if they intentionally suppress that evidence, that is outstanding and egregious misconduct that may warrant severe sanction. And at this point, I don't know how you could ever let this guy go into a courtroom on behalf of the Commonwealth, and go and say, trust me, I've turned over everything. There must be, I think I commented on this earlier in your thing, like there must be post-conviction lawyers who do, this kind of work in Massachusetts who are salivating at having a review of other Lally cases, making FOIL requests about, what was turned over and what's not, and finding out what else would just slip through the cracks, because this guy is basically saying, I have no real process of how I ensure that discovery gets turned over other than I ask the state police, they say, you've got it. And I say, here you go. And what's for lunch? I mean, that's process.
Were you there when she pulled out the transcripts from prior hearings where he said, Your Honor, we've complied with all discovery, and
So that in and of itself is sanctionable, because you have to have a good faith basis to say that. And, he can say, well, I had a good faith basis at that time. I think it was 2024 when
January 2024.
When he said that. And, obviously at the time, there was no reason for the defense to say, well, what about this? What about that? And, he's going to say, as he did, well, I have no specific memory. But what happens now, and what, the judge ought to allow the examination on, is what was the basis for your representation to make that at that time? All right, let's all understand you're not lying, all of that, but you must recognize that you have to have a good faith basis to say that you have complied with all of your discovery obligations. I mean, you have to exercise due diligence before submitting a certificate of compliance. What is the due diligence? We know he didn't do it in Karen's case with the Sallyport video, because they turned it over piecemeal and then turned it over after. What was good faith in this case? That Proctor said you have it? What is Proctor's explanation going to be? Why didn't he turn over the search warrants? I don't know that there's anything in there that matters, but like, what are you doing? I mean, the idea that this guy professes to be a serious detective on top of being probably corrupt, at least in Karen's case, this guy is every bit the joke that Lally is. And I assume, I don't know why they're calling Tully, other than for him to say, oh, I don't know. No one told me. What do I know? Which is probably true, right? I don't know. But this is unbelievable. And it's such a shame that these people were not ordered and compelled to be grilled over all of the shenanigans and oddities that occurred at the pre-trial stage of Karen's case, and what led them to certified disclosure, that they disclosed everything when they in fact were disclosing important evidence to the Reed defense after the first trial.
Right.
Which he recognized. His obligation continues throughout. It's all word salad. He doesn't mean it, because he doesn't show any good faith or due diligence in any of this.
Everybody wants to know if Proctor is going to be able to plead the fifth when he comes back on August 5th.
I mean, look, if it's incriminating to him, I assume he can. It's different subject matter. It's not like he testified about this specifically in connection when he testified at Karen's first trial, when he did testify. So I suppose he could. Why not? I mean, if he didn't disclose evidence, depending on what his reasons are, I would imagine it would be smart for him to just say no more. I mean, look, he's disgraced. He's never getting his job back.
He's trying.
Well, in some ways, not that it's legally sufficient, because it's not, and it's kind of pathetic actually, but Lally did kind of throw the blame on Proctor today. But, you know, in a legal sense, that does nothing. Lally is the one who's in the crosshairs here. He's the one who ought to be reported to, you know, the Ethics Commission, the Board of Bar Overseers, for what appears to be, at best, gross negligence and stunning incompetence. At worst, you know, deliberate suppression of evidence, which has occurred in this case and the other one he was prosecuting at the same time with the exact same detective. And maybe, you know, maybe they shouldn't have these guys be buddy-buddy. I mean, you have to wonder if, like they do it in other jurisdictions, if Proctor was just a detective, somebody you know, you don't literally see in the office every day, have lunch with, you know, drink beers with, make jokes about God knows what. But if he was just a detective and you're just a prosecutor and you say, where are the search warrants? And he says, I'll get it to you. And he does that again and again, and months go by. If he's a regular detective, how about at some point you say, dude, go get the evidence now. This is no joke. I have obligations. Is there a problem? Why don't I have this? Did you lose it? Where is it? Tell me what's going on. They don't do that. They just say, trust me, bro. And this is all campaign fodder for people running for Norfolk to DA to say this is the cultural problem with all of these people. And that the prosecutor testifying today basically is saying, look, I trust them. We do the best we can. And honestly, I don't give a shit. I mean, this guy looks more concerned about, you know, his next cigarette and lunch than he does with what's happening here about, you know, some guy, whether he's a mope or not, who's just rotting in a jail cell, who can't get discovery for years.
How do they have no tickler system?
They have no system. They have a, you know, again, as I'm sure the lawyers are going to be excited about, they appear to have a system where there is negligent oversight, which is probably why when the lawsuit is filed, in the caption, it'll be, you know, Norfolk District Attorney, you know, Michael Morrissey in his official capacity, and, you know, Adam Lally in his official capacity, and Hank Brennan in his official capacity, and so on and so
on. This is wild. I mean, he's implicating the entire DA's office, that they've been doing it this way for like the 20 years since he's been there.
It is.
And Judge Krupp wasn't having any of it.
I don't think I mean, look, obviously Canone didn't want to hear it. So, but I don't think any judge who's being honest to the process would find any of this okay. I mean, obviously Krupp says, what's the prejudice? And that's an issue that, you know, the defense will have to deal with at some point, you know, in terms of what sanction they get, whatever they're seeking. I assume they're seeking dismissal, but it's clear that there is no process at all in this office. And these are not rookie ADAs dealing with a petty larceny case who forgot to turn over the surveillance video of the Dwayne Reed where the guy's stuffing, you know, deodorant down his pants. I mean, this guy has been a lawyer for 15 or 20 years. He's been doing homicides for the majority of that. He was getting awards. Hell, that award is named after my cousin, for Christ's sakes, in like 2011 or 2012 from this office. He's obviously was given the biggest case in that office. He was given the Karen Reed case. He was part of the trial team in the second case. He handled this murder case that's obviously an important case to the people in the county. And he has zero clue or interest in complying with his discovery obligations. It's an embarrassment. It's a disgrace. I don't know how they let him touch anything other than traffic infractions at this point.
Wow. I mean, yeah. And apparently he hasn't handled that. I mean, he tried a lot of cases in district court, but I think he didn't even know how many cases he tried in Superior Court. Like, his testimony was wild. And
wonder, how did he get the Karen Reed case? I mean, you have to wonder, is it because he's a patsy? He's a yes man. He's going to go with the flow. I don't know if any of that's true or not, but he's clearly was not competent to handle that case. And he's got his hand in the ethical cookie jar all over Karen's case. Don't kid yourself. They all do. He's a mess and whatever. I don't even know this defendant's name in the case, that we were watching today.
Myles King. Yeah, Myles King.
I mean, how does, and by the way, even in turning over evidence, you know, sometimes lawyers complain about, I didn't receive this or I didn't receive that. And some of the evidence can be really, really irrelevant. I mean, you know, it could be what they call like the command log at the precinct where they log in the prisoner, which is literally usually nothing. You know, it can be a minor voucher of evidence that is nothing. 6 search warrants in a murder case that presumably led to the seizure of compelling evidence to help convict a killer. And we don't know where the affidavits are or why. And by the way, I think he said, I got half an affidavit.
Yeah.
What the hell does that even mean?
Like there's pages missing.
Yeah, there's like a 7-page affidavit, and let me give you 3 of those pages, and we're good here, right? We're good. I mean, see, I think she should follow up on this. That in and of itself, without more, if Lally takes his job seriously and he looks at it, even if he left that day and he says, okay, I've got pages 4, 5, and 6 out of a 6-page document, where are 1, 2, and 3? When did you recognize that? When did you confront Proctor with that? Did you get it right away? What did he say? I mean, we heard any discussion about why the now terminated and disgraced trooper is turning over half affidavits. I mean, who the hell's ever heard of anything like this?
And he said, but I had all 6 of them at the grand jury. Okay, then why weren't they in your file? Why did you need to go to Proctor to get them? That's a problem.
So I didn't hear that.
Yeah.
Part. Wait a minute. So, look, wow.
Yeah.
The warrants were from, I think he was, if I recall correctly, like July to November 21, give or take, roughly.
Yeah, I think so.
When was the grand jury in this case? Roughly.
Hold on. I don't know. I took notes, but I can barely read them.
Because this makes it 100 times worse.
2021. The grand jury was July, August, September, and November of 2021.
Okay. So wait a minute. This changes everything, not in a good way for Lally and his friends watching. Lally introduced the warrants, or at least made reference to the warrants in the grand jury.
Yes, that's what he said, right, chat? That's what I remember him saying.
Okay. So did he show the witnesses the warrants?
He wasn't asked that part. He just said the answer to one question. He said, well, I had them at the grand jury. I'm gonna have to go back and watch it again.
Okay. Now, he says I had them. I interpret that to mean I have a physical copy.
That's what I would, and that's what I would interpret it to mean too.
But either way, if he's talking about 6 warrants with certain dates and numbers at the time of the grand jury, that's what lawyers like us call actual knowledge and actual possession. At that point, Proctor's irrelevant. Okay. I mean, not irrelevant. I shouldn't say irrelevant, less relevant. Because at that point, I don't even care what happens with Proctor. I'm now talking to you, Lally, and saying you had actual knowledge of the 6 warrants in 2021. They're in your actual possession, custody, and control. You're the one with the discovery obligation. I made the discovery demands to you. Those are specific requests, which make it even worse. You draw his attention to it. And why are we even talking about Proctor at that point?
Yeah, because she said,
a lawyer. This is why he has a lawyer.
He said, I send the discovery request to the troopers and to the Milton PD to get them to respond to them. And then he said, June of 2025 was the first time that I learned that the search warrants were not turned over.
That makes 0 sense.
Agreed.
Because if he had him in 2021, he certainly, again, as an experienced prosecutor, has to be familiar and should be familiar with his ethical and professional obligations to disclose Rule 14 and Brady material. He gets a specific demand for it, and he doesn't disclose it. And then he later gets, bits and pieces of half affidavits, which again, I don't understand. And at that point, his mind isn't triggered to say, oh shit, I need to, honestly, he should be fired today. There is no explanation that he can give to save this, because if they had it in the grand jury, he had absolute knowledge. And the fact that he's now shoving this on Proctor makes it a lot worse. And it makes me question what he said in Karen's case, which I thought at the time, which was, if you honestly believe what they submitted in Karen's case, when the three lawyers, remember, they did their three-headed affirmation, which was ridiculous, signed the same affirmation.
Yeah, right.
And
We all sign it.
there were no facts attributed to anyone. And instead, they submitted like a brief affidavit of whatever it was. And but the sum and substance of it was essentially Lally saying, I had no knowledge of the Sally Port video. It was all Proctor. He had it for 2 years. He never gave me anything. He never showed it to me. And put that now in the context of what you heard today, when you know Lally had actual knowledge of discoverable evidence, he didn't disclose it. And he claims, well, Proctor didn't give it to me either, except for the 1.5.
Right.
Which also raises the next question, which I don't think she asked. Maybe she'll go back. Did he disclose the 1.5?
Right. Or did Proctor go home with them? Or were they just looking for Proctor's affidavits? Did he just come in with the warrants with no affidavits attached?
Because I guarantee you this, and again, this is why I don't believe Adam Lally. I think he's lying, okay? It is what it is. It's my opinion, but there's a common sense component to this. He certainly knew he had him in the grand jury. He gets 1.5 affidavits, that is a red flag of red flags. That is
a affidavit. A affidavit.
That is a code red for what the hell is going on. And of course, any prosecutor who values his or her ethical obligation, professional obligation, at a minimum would do two things. They would call Proctor and say, what the hell is going on here? That's number one. But number two, I'm turning over what I have. Okay. Now that's going to start a really interesting conversation when, unfortunately for the DA, there's what we call a real lawyer for the defense, which clearly there is from what I saw today. Obviously, she is, she's awesome. Yeah, no, she's great. But any real lawyer would say, thank you for the 1.5 affidavits. I have questions. Number one, what is the half affidavit? And number two, why am I getting a half affidavit? And number three, is there any more? And wouldn't it be nice to know what Lally would have said in that conversation? So the question that has to be asked of him is, what did you do when you got the 1.5? Did you complain to Proctor? Did you ask questions? Did you demand the rest? Did you turn that 1.5 over to the defense? I mean, it sounds like there could be another 3 hours across here with this guy.
Yeah. And the other thing he said was, well, first of all, so the case was taken away from him in October of 2024 and transferred over to another ADA, Jennifer Hickman. I'd like to know why that was exactly. And I think
he's not lead counsel. He's a potted plant to Karen's case at that point.
So she asked why, and the judge sustained the objection. And then he said, he was asked about his procedure. Well, is that your procedure? And he said, well, back then that was my procedure, but now I've changed my procedure.
Right. So my procedure is to now what? Actually demand from the state police, tell me what the hell is going on. And this radical shift in procedure and competence occurred in the last couple of months,
I guess.
Well, the question, sir, is what the hell were you doing and why in the prior? And see, I mean, look, again, I don't know what this judge would allow, but, you know, when we do these kinds of questioning, one of the things that, you know, we always ask is what training have you received about?
She asked that.
Okay.
And it was sustained as well.
So
what training did the Norfolk County DA's office give you? Judge was like, yeah, that's not relevant.
So that occurred before. First of all, that's entirely relevant.
Or I don't know if he said relevant or he said, I don't remember what his reason for sustaining it was, but he wouldn't allow.
Well, that's
to get into it,
because if there is none or it hasn't occurred since he was a rookie DA, that's kind of important. And I mean, this is the kind of stuff that would be critical, obviously, at a 1983 action that's coming about policies, training, customs, and all of that. So, you know, I missed that. That was in the beginning, I guess.
Yeah, that was like how she started off about his training and how long he's been in ADA.
Did she ask him or try to ask him, like, Mr. Lally, can you explain what Brady means? Do you have any, you know, what do you think it means? No.
I don't think she did.
he probably wouldn't have allowed it based upon those rulings. But I don't. I mean, any real prosecutor's office at this point would be so troubled by what they're hearing today. This was our, one of our star guys. I mean, he got the Karen Reed case. That's the only conclusion you can make, is that and he was on the second team as well. So you have to conclude that they consider him, one of the good guys, one of the professionals. And he has no clue about Brady and discovery and thinks it's an outsourceable function to people like Michael Proctor and the rest of them. And which is, and by the way, I mean, if you're like the colonel of the state police again, and you're back for more of this, and you see once again, here's your wonderful state police people who not only don't disclose search warrants for years, but when they do, it's often in halves. Affidavits are disclosed in halves.
Right.
I mean, is it PDF? Is it in your system? I mean, what are they doing?
They just turned you over 4,000 blank pages, by the way. I had Aiden on my show last night. I mean, 6,000 pages from Cosgrove and 4,000 were blank.
There was 4,000 blank and about 300 or 400 colored black, like top to bottom. So there was a distinction between blank and redacted. There was,
right.
Who did, I mean, whatever, we'll deal with that. I don't want to, get too.
But this is what they do, is what I'm saying. This is what they do.
This is what they do. What I can't understand also, again, is why a prosecutor in a homicide situation where there's going to be a lot of discovery, the cases are so serious, you don't want to lose on technicalities and discovery violations. How do you not make a very simple list of what you disclose, bait stamp numbers, this to that, make a cover sheet, have them sign for it, and state in open court, mark and file it with the court. I know people get triggered about filing things with court that aren't necessarily like meant to be court filings per se, but put it in the court file, have a record of it. And then if this comes up 4 years later, here it is. Like, I have a bait stamp copy. They signed off on it. There's nothing to see here. And instead you're getting Lally saying, I don't know. I don't take notes. I can't answer this. Who knows? And, they told me they would do it and I forgot.
Lally's going to be the next one to be rehomed or terminated. I mean, he's got an ethics attorney with him. His attorney is like the head of the ethics board or something.
I have zero confidence in the Norfolk DA to do the right thing, obviously. But what I can tell you is that in a real DA's office, and if they are a real DA's office, at least in part, they will do this. This would scare the bejesus out of them. And they would call him in and they would do an internal investigation, not assuming he's dirty, but just having a real serious conversation about how long has this trust me bro method been going on, where you don't check things. And they ought to be doing a survey of his prior serious cases and seeing what's out there. The answer is they're not going to do that. We know that. They're going to, they lost today that the public knew there was going to be a hearing. I mean, that, in a perfect world, this would have been private, not on Zoom, not in the Boston Herald as it was over the weekend, and not people, with your influence.
I mean, when I called the court this morning, she told me, no, there's no public Zoom information. And I said, well, are there cameras in the courtroom? She said, well, I just saw them walk in. I said, well, do you know who it is? What network? She said, well, now you're asking a lot. And I was like, okay. And then Broken Baker was streaming it. So I called back and then they give me the Zoom information because I got a different person on the phone. They did not want me covering that case.
No, but that's also improper. I mean, court proceedings are public. Unless, they're not supposed to be. And certainly there's no reason to keep any of this private. And it goes, this is what we were saying in the other case. You can't conceal and impound and make secret information simply because it's embarrassing to the Norfolk DA and the state police. That's not how it works. There is a presumption of openness. Do you know that they just had in New York yesterday, in Queens, a murder conviction reversed because someone in the audience was thrown out of the courtroom by the judge in Queens, okay? without being warned, without anything. The judge, the guy either fell asleep, made a face, and the judge just said, get him out of here. Okay. The guy was convicted of murder. The appellate division, the second department in New York, said the evidence of guilt is strong, and they nevertheless reversed a murder conviction because the trial judge in Queens, Alois, if you know him, improperly told a member of the public to leave and therefore denied the defendant his fundamental constitutional right to an open trial. Okay. If there was ever a technicality to lead to a reversal in a murder case, it was this, but it was all about the importance of court proceedings being open and a judge simply overreacting before he actually threw the guy out. To the extent a convicted murderer is getting a new trial, the trial or the incident occurred like 15 years ago. Who knows whether it's a viable case or not? I don't know. The case was actually in the New York Post yesterday. It was funny because my first thought was, this totally sounds like a Ron Kuby case. This has to be Ron.
Mm-hmm.
And it was actually in the article, but it wasn't his case. He was just commenting, and I just assumed it was him because that's like, you know, one of his things. But that's how important an open court proceeding is. And you're getting told by representatives of the court, like, piss off.
Mm-hmm.
Really.
Yeah. And
Nothing.
he doesn't seem to know what he's required to do. It's wild.
And it turns out there was a lot to see here because you just got an incredible class about how demented and awful and untrained and I think the big word, indifferent, these prosecutors in Norfolk County, most of them anyway, are with their professional and ethical obligations. And it's shocking that this is still happening. And, you know, it's amazing because he only learned last month, he said, and he's been through the Karen Reed ringer and been getting dragged for 3+ years. And he's still clueless about his other cases.
Yeah, maybe he was a little distracted by all of the malfeasance in the Karen Reed case. Just saying.
Unbelievable.
What else has he been hiding? It's going to open up the floodgates. It's going to open up the floodgates for every case that he's ever tried.
It should.
For every case that he's ever been assigned to, and for every case that is ongoing that he was assigned to.
It's just bittersweet because this should have been.
Because now it's not just Proctor, it's Lally too.
This should have been a hearing in Karen's case where the viewership, as big as it was today, would have been 20 times large. 1 million people would have been watching, and to see how the sausage is really made in Norfolk County, and it ain't pretty.
Mm-mm. It's pork. It's a long pork sausage, man. But this opens up a whole other floodgate of not just cases that Proctor has been handling, but cases that Lally has been handling with Proctor maybe not have been the lead investigator on. Maybe it was Tully. Maybe it was Buchanan. Maybe it was, who knows? But now Lally has been outed. He outed himself as being the guy who doesn't understand what has to be turned over, who doesn't double check, and who just is like, trust me, bro, I gave you everything.
They're so loosey-goosey. They're so indifferent. And the reality is this culture in that office and the culture of non-disclosure or not caring about it, the indifference, the avoidance, it's pervasive. I mean, it's obvious. I mean, look at all of these cases that are on the radar. I mean, you hear about, obviously, everybody knows about the Karen stuff. You see what's going on with the Brian Walsh stuff, the sketchiness over the consent to search and the warrants. Everybody knows about the Sandra Birchmore stuff. And you say, how the hell is this happening in every big case they get with the same state troopers, the same DA's office? And these are the big cases where people care and watch and are kind of on the radar. What do you think's going on in the darkness?
Right.
Where nobody cares publicly.
Right. Or they don't have a high profile defense team or, you know, a defense lawyer who's on the ball, and they maybe have a public defender who's overloaded and overworked and is just pleading guilty because, you know, got a heavy caseload.
I mean, look, I totally agree. I mean, I don't know anything about this defendant at all, but if he didn't have, you know, obviously an invested, skilled attorney who's willing to, you know, raise hell and advocate zealously, Who knows? Same thing with Karen. Obviously, if she didn't have the level of lawyer that she had, who knows? And you just, I mean, obviously, Sandra Birchmore didn't have a lawyer. Look what they did. They swept that one away. And it actually took, I guess, the family to launch their own investigation and get federal attention to do that. So, yeah, you have to wonder what happens with the people who don't have the resources or access to publicity and shining a light on it. It's insane to see what's going on there, because they don't, I mean, watching him today, all I kept thinking was he's just jonesing for a cigarette and lunch. They don't care. He recognizes it's important. I mean, God bless him. He brought a lawyer with him. That's a smart move. I don't blame him for that. It's the right move. But there's just this, I don't know, I asked him, I didn't do this. And there's just no concern about your role as prosecutor. I mean, the first role of the prosecutor is be fair. You know, get the bad guys, but do it fairly. And maybe the defendant is a bad guy, but you're not doing anybody a favor, even if he's guilty as hell, by screwing up the case and getting all the evidence suppressed or potentially the indictment dismissed because you don't understand what Brady is. That's not good.
Right.
That's not just.
Understand and fulfill your obligations as an ethical prosecutor.
20 years.
You were a prosecutor, you know.
Listen, you know, again, I would have loved to have heard the testimony about what training they had and how serious it is and what they do and whatnot. And I assure you that when the lawsuits start coming, you know, the 1983 lawsuits, that's going to be a big deal. And when the subpoenas start flying, I mean, I've seen these cases. I've been involved in some of these cases. The subpoenas are going to start filing for, you know, do you have a Brady training manual? If so, send it and send every version. When was it updated? All the courses that you send people to, all the the disciplinary records, internal files about, I mean, the discovery in the 1983 action is going to be a proctology exam of the DA's office, Brady practice like you've never seen. Okay. And I mean, I've seen this in practice. It is ugly. And you know, they'll try not to disclose it. They'll try to do this. It's all going to be discoverable. They're going to get it all. And if they don't get it, they're going to get notice of it doesn't exist, which I would suggest is worse.
Who maintains the Brady list in Massachusetts?
I don't know. I mean,
yeah, like who's responsible for putting people on the Brady? Whose obligation is that?
I would assume ultimately the district attorneys of the several counties, you know, they're the ones, again, that have the disclosure obligation. And if they have information in any particular case that a cop or prosecutor, you know, is at risk in that way, and there could be evidence favorable to the defense of that they would be the ones to do it. I mean, that's how they do it in New York, you know, as part of discovery. You know, it's the DA's office who will tell you if the cops have ever been, if they've ever been sued, and what the outcome of that was. Have they ever been brought in front of the CCRB, with, you know, the Citizens Complaint Review Board, which is like public advocacy saying the cops did this to me, whatever. If there's any other problem. I mean, I've gotten notices where, you know, this officer gave testimony in this case that a judge found not credible. They have to disclose that, or the DA determined that they weren't credible. But the problem is, who's policing the police? I mean, if that's how they do it in Norfolk County, then you're counting on the Norfolk County DA to do it. And do you trust them? I don't.
Hell no. Some people, Matt, that each DA's office has their own list, but you know, there's a list floating around online that people think is real, and it's not real. Anybody can put anybody on there. It's not a real list.
Yeah, I've never seen anything like that. I don't know what the online stuff is.
Yeah. It's
I
not a public list. Like, you'd have to be notified by the DA's office, and you'd have to be an attorney of record on the case to get the information. It's not something publicly available.
I don't know what it is. I mean, colloquially, I mean, we just call it the naughty list. Each DA's office has a naughty list of, you know, and I believe as part of the naughty list too, they'll notify whatever police department it is and say, look, this person is no good for us. And that usually will streamline the end of their career, you know, because if they're not credible and reliable and the DA's office is saying we can't even use this person, then they're, you know, half useless. You know, since today the word of the day is half affidavits, that makes them half useless as a police officer.
This is going to get so much better. I just can't wait. Thank you so much for jumping on with me quickly today, for sharing your thoughts, because everyone loves to hear from you. And people are like, bring Mark on. I'm like, I don't know where he is. He could be in court. He could be running. So it just so happened that you actually were available. So thank you.
I was. Glad to
Thank
talk.
you.
All right. Take care.
We'll be back for the part 2 of this because I can't wait. Thanks,
When is
Mark.
that? It's in
August 5th.
Okay. Yeah,
August
that'll
5th. But there's a hearing on Walsh on Thursday. The motion to dismiss on Walsh I'll cover as well. So this could get interesting.
The first defense lawyer is not testifying for the defense in that case.
Say that again.
I mean, I don't know that as well as you do, and I don't want to hog your time, but I mean, my understanding was the lawyer gave some degree of consent. The state police overran that, and then I think it was mechanic came up with this fakakta explanation that a real lawyer, agreed orally to just extend the consent to this, which I'm here to tell you, there's no chance that's true without a writing. So my question was, is the defense in Walsh calling the former yet real lawyer to say that's bullshit?
She did testify at the hearing on the motion to suppress. It was not televised, but she did testify. She's a white collar criminal attorney.
It was in writing or non-existent.
It was in writing between her and Lynn Beeland that it was only for communications between Brian and Anna for a 1-week period. Instead, they did a full extraction. It was Garino and Tully and I forget who else. And so they got his location data and they got his Google searches. And they took the Google searches and then they used those in the search warrants to search his house, his car, fruits of the poisonous tree, and they used his location data to go to Home Depot. They got video of him buying all kinds of supplies to clean up what could be a crime scene. They got video of him at other places, like buying rugs at Home Goods. And all of that was because of the outside the scope extraction they did of the phones. They didn't have a proper warrant to search the phones until after they already had all that information.
So Buchanan is the one, though, who claimed, but the lawyer told me orally it was okay.
Yeah, so my understanding of the written agreement, he says, was that it was okay for us to just get everything off the device. And it was the kid's iPad, too.
Okay, so that's probably perjured testimony. And here we go again with him and the inverted video nonsense and all of that. But if they literally took limited consent and ran roughshod over that and going farther than they were allowed, found the good stuff, and then used the good stuff and put that in the affidavit to get the search warrants, which presumably the warrants themselves are clean based on the affidavit, but not the information that led to the affidavit, and then found the really good stuff, then what everybody needs to do is take a deep breath, sit down, and prepare themselves for what could be devastating consequences in the Brian Walsh case.
They're arguing inevitable discovery.
They're always going to argue inevitable attenuation, all of that stuff. You know what? Whether it's inevitable or not, I'm not informed enough to say at the moment. But the bottom line is they got consent to look at certain things. And if they can't justify stumbling upon the good stuff as part of that consent, it's very tough to argue inevitable when all the bad shit came from the bad part. You can't justify, illegal searches, finding poisonous fruit, and then rely on the poisonous fruit that was illegally obtained and say, see, it's inevitable. I mean, that's like a really, that's a great argument.
Yeah. It's interesting. And listen, better one guilty guy go free than, one innocent person is sentenced to life in prison.
Yeah. I mean, I don't know what Massachusetts rule is on whether they have, like in New York, for example, if the initial conduct is illegal, you can't rely on inevitable discovery. Like the whole thing, you're screwed. And I don't know what Massachusetts is. And then I don't know who the judge is. And then there's a really, really important rule that every state and every lawyer is familiar with in criminal practice. It's called the bad guy rule. It's not really a legal rule, but it's a real rule. And, you get confronted with the doomsday scenario if you're a judge, right? the doomsday scenario is that this Brian Walsh guy, in a factual sense, appears to be presumption of innocence and all that, full disclosures. I mean, look at the Google searches. He appears to be guilty as hell, right? I mean, who's doing that? However, his rights pretty clearly appear to have been violated, and 90% of the evidence goes down the toilet. The only question then becomes, does the bad guy rule come into play? And, example, inevitable discovery, taking a liberal interpretation of inevitable discovery would probably be just a way of saying, well, the bad guy rule, we can't let this guy go. This is, but this is, I don't know how this isn't getting more attention. I mean, that is insane.
They, because of the location data that they took from going outside the scope of the search warrant, they found out that he went to certain dumpsters in town. And so they went to the dumpsters and they found like a Tyvek suit. They found out that he went to like Home Depot, and they have video of him buying a Tyvek suit. Then they find the Tyvek suit, and they find Anna Walsh's purse and her coat that she was wearing and all of this. And they find all of this stuff before they have the actual warrant to search the phone. I mean, I think
that's a problem. Was she known dead at that time, or were they still investigating, hoping to find her?
There's no body. She was a missing person at that time, and there's still no body.
Like, when was she reported missing, and how many days later was all this stuff?
She was reported missing on like the 4th of January, and then they get his phones, I think, on the 6th, and they extract them and return his phone and his iPad to him within 18 hours. They don't get a warrant for the phone until the 9th, but they collect all this evidence before the 9th.
They're going to also put together some half fakakta argument that, there was an exigency to find a missing person and this. I mean, if this was on a law school,
they didn't even argue that in the papers.
If this was on a law school evidence exam where there's like no emotion and no real life, the correct answer would be suppress everything that flows beyond that search. And if what you're saying is true and all of the other evidence comes from the tainted evidence, the whole fruit of the poisonous tree concept. Wow.
Yeah, and Buchanan testified, and he was like a smug SOB. And, they told him, look, there's no crime. We just want to see the communications between you and Anna so we can try and find her. There's no crime here. We'd have to, get a warrant if you were charged with a crime. I mean, the testimony was wild.
Well, that raises another interesting thing, which is whether, his consent was truly voluntary. I mean, I'm not trying to defend this guy. I'm not his lawyer. I don't want to be his lawyer, believe me. But, if you're trying to gain consent and you're feeding the guy a bunch of BS and he's like, oh, okay, I'm relying on it. It's an argument. Again, I don't know the Massachusetts nuances on consent, but
then they had the writing after that. Then there was the writing. So the writing rules.
The writing is going to rule, and there's no judge, unless they're employing the bad guy rule, who would ever say that a serious lawyer who put the consent in writing, yet somehow mysteriously, allowed it to get expansive based on trust me, bro, because, they'll never do anything.
It's Judge Diane Frenier, and it's a Norfolk County case. It had been Canoni's case. Judge Frenier sits, I think, in Plymouth or Middlesex, but she's trying it in Norfolk County. So buckle up.
Oh my God. What a mess. They're the gift that keeps on giving, though, for interesting content. I mean,
no shortage of content out of Norfolk County.
Insane. It's just like one regular county in Massachusetts has more scandals and absurdity than the rest of the country combined. It's insane.
Thank you so much for jumping on. I'm going to jump to the super chats, and then we're going to pivot over to Stephen Stearns. Thank you. Love you. Bye.
Bye.
All right. That was awesome. You asked for it. You got it. If Mark is available, he always jumps on. Thank you, Snark Tank, for your interesting question, which I will not. Would you rather be called Yuri's nickname forever or be the Coldplay CEO? Are you asking the chat or me? Because I'm not going to answer that. Happy to be in the bully free zone. Thanks, Glock, for me. Tofu Brains, Proctor is suing for reinstatement or for money. He's suing to try and get, he has hearings scheduled. There's an appeals process going on with the Massachusetts State Police to try and get him his job back. So he's looking for his job back. He's not suing for money at this point. Thanks for asking. Dennis, incredible interview with you and Turtle Boy. You are the Larry King of interview questions in female form. Oh, thank you. I like to say it's more of a conversation really than an interview. And I think those are the best kind, right? Because you're not going to we pivoted so much. I had so many things I wanted to ask and I just had general notes. And then depending on the answers, that's where we went with it. So thank you for that. Sarah, Mel, my kids were playing court. They had red Solo cups and showed the fan at sidebar. I got curious hearing I'll allow it in their room. That's hilarious, Sarah. That is so funny. Edwina says, what is this magic? We love you. Vetero, thanks for your 20. Smurf Anna, the lack of understanding of ethical obligations goes above Lally. Someone had to train him when he started. He's the face of it right now, though. Oh, yes, he is. Ms. Holmes, face it, Lally gag has no practice, not fooling us. Andy Shell, I would love to see you and Rosemary Scapiccio talk. That'll be fire. Yeah, that'll be great. She can't talk about this right now, though. Kyle, can you explain the meaning of malfeasance versus malpractice in law? I don't have time to really get into that right now. However, malfeasance would be a criminal charges against a public official. Malpractice would be a civil case by a client against their attorney. And that's like the short of it. Hopefully that helps. What an amazing, if not woefully, late exposure. Greg, is there a possibility regarding loss of judicial immunity for Judge Cannoni? It depends on what happens. Depends on what happens. She's protected for everything she does within her judicial role. But for things that go outside the scope of ruling on a case and outside the scope of her judicial discretion, if things are criminal, if things are if there's fraud, if there's a crime, she could lose her immunity, but that remains to be seen somewhere in the future. New Jersey Kathy, this is BS. The feds have to create a Vaughn undex and swear under penalties of perjury as a Fed preparing for discovery. It's no different for the state. Thank you, Kathy. Perry Raven, Judge Krupp isn't great. I hope people know he put Aiden in jail. Yep, we talked about that last night. But today he made Lally get on the stand. That's a start. Brent says, is the way the Norfolk DA's office, the way all counties in Massachusetts are run? I don't know. I'm a New York attorney. People say, who are from Massachusetts, that the corruption runs deep and thick, and it's full-throated. Double Shovel, she wanted the affidavit filled out by Proctor. Gotcha. Just keeps on giving, says half-a-davit. Oh, I like how you changed your name. That's cute. Crazy Cat Lady, I loved you and Aiden last night, and love you, Mr. Betterow, today. Thank you. I'm bringing you all the content. Tara makes the hoodie silence from Lally crystal clear. Good point. Good point, Tara from Canada. Ocean Beach, toots. You guys need to calm down. Nothing to see here. We conciliaries and capos doing BAU. Now, how's Bows get us the spaghetti? Queen Melanie bringing breaking news and cutting through the mass lighting. Oh, can I steal that? Mass lighting? That's awesome. Thank you, Ocean Beach. Thanks, Jen. Says Mark, waving from the Tappan Zee. Peace Geek. What about the judges seemingly not caring if disclosure dates are met over and over? Listen, it happens in a lot of cases. So I can tell you that is very common. That disclosure dates and discovery dates are often pushed out, and it's not uncommon. So, sometimes you get to a point where it's like, all right, enough is enough. Meatball ship is aflame and taking on water SOS, says Scott McGinnis. Greg, prosecution misconduct, exactly what happened in the Baldwin Rust case. Yes. And that judge threw that case out right away. Snark Tank, why did Jackson message the Boston commissioner about it? No, why did he? Oh, because he's saying she needs to go on the Brady list. And I'm sure he also sent it to the district attorney's office, but he wanted, so the news would pick up on it, maybe get some publicity, make it known that it ain't over. It ain't over. So does the Boston commissioner have an obligation to notify the DA's office in every county? Because she's Boston PD, so I don't think she's just assigned to one county, but I really have no idea. So I can't say for sure. Maureen, thank you. Says, thanks for all you do on Venmo. I appreciate you. All right, you guys, I'm going to have a lunch break. You too should have a lunch break. And what is going to happen next is when I end this stream, it's going to teleport you over to 1:30. We're going to cover Stephen Stern's plea hearing Apparently, allegedly, maybe he's going to plead guilty to all the charges for all of the crimes he committed against Madeline Soto, and I am here for it. That guy should rot in hell, and they should throw the key away, and he should burn. Burn, baby, burn. Apparently, maybe they're going to have victim impact statements too. So I'm so glad that I don't have to cover the trial on that, but we will cover this hearing in about 35 minutes. So I'm going to hit end. It's going to teleport you over there. Do all the things that YouTube likes. Please smash the like button on your way out. Comment respectfully. Share the stream out so everyone knows what happened today. Lally was on the stand. It was beautiful. And buckle your seatbelts. I'm going to teleport you over there and stay cool, stay kind, stay classy. Thank you to the moderators for keeping it classy. And we'll see you again in about 35 minutes. Go have a lunch and a drink and hydrate. See you in 3, 2, 1. Safe travels, cupcakes. Peace.